Good morning, members. The sitting is resumed. Members, the committee is currently considering the Sentencing Reinstating Three Strikes Amendment Bill, and the questions we are debating on is Part 1, Clauses 3 to 12, Amendments to Sentencing Acts 2002 and Schedules 1 and 2. The question is that Part 1 stand part.
Mr. Chair.
The Honourable Nicole McKee.
Thank you, Mr. Chair. Last night, when we finished up for the evening, I was asked a question by the member Tom Rutherford around the changes to sections 86, which is clause 7 in the amendment bill. And I'd just like to take some time to answer his question around some of these changes. In 86J, the qualifying sentence threshold at stage 1 has been amended to 12 months from 24 months. We also have put in there that if an offender has earned a first strike but wins an appeal and gets, say, home detention, then the record of that first strike will be removed because it's no longer imprisonment. At 86M, we have said that if on appeal the court issues what becomes a qualifying sentence, then a strike warning can be issued if indeed it does qualify at appeal. We also at 86M are noting that if an offender is not before the appeal court when the decision is made that would give them a strikeable offence, then the offender must be referred back to the original court in order for that court to provide the offender a warning. At 86P, R and S, we are removing the words, quote, in writing. And the reason why we are removing those words in writing is because we believe that the oral indication to the offender that they are receiving a warning is the official warning that they receive, and that to have it in writing will be to confirm that the offender has received that oral verbal warning by a judge directly and gives them a record of it. At 86T, we are removing section 102 from matters that apply to 86T, aligning with the wording used in the Sentencing Act in 2002. It clarifies that 86T does not prevent consideration of any mitigating factors. And at 86U, we are allowing the court to revoke a warning when a pardon is granted. And while I'm on my feet, I think it's an opportune time to speak to my own amendment paper, Mr. Chair, and the reasonings for why I am bringing it to the House. The amendment paper that I have submitted amends Schedule 1 of the bill, which reactivates previous warnings that meet the relevant thresholds under the new regime. The paper ensures that when a previous warning is not reactivated, a previous final warning could be reactivated as a first warning under the new regime. This will happen when the previous final warning meets the threshold of above 12 months imprisonment, including sentences of above 24 months imprisonment. As it was returned from the Justice Select Committee, the bill is currently drafted did not reactivate a previous warning in certain scenarios for a sentence of more than 24 months imprisonment. So I believe that this amendment paper is necessary, Mr. Chair, to give an illustration. An offender may have been sentenced to 10 months imprisonment for a previous warning and say 27 months imprisonment for a previous final warning. So in this scenario, the offender's previous first warning will not be reactivated because it didn't meet the threshold, because it's 10 months, not over 12. Only a final warning for a sentence of more than 12 months imprisonment, but then up to 24 months, will be reactivated, but not for sentences above the 24 months. So that offender's final warning would not be reactivated, and I hope that that explains my amendment paper that I've put forward.
Dr. Lawrence Zunan.
Thank you, Mr. Chair, and thank you for that explanation, Minister, although albeit I am surprised after what the Minister said yesterday about consistency that we're seeing an amendment paper today. So I want to kind of pick up on what the Minister was just saying before, two things that the Minister was saying before, and I want to go back.
Just to clarify, this showed up last night.
Thank you. Thank you, Chair. So, but I want to pick up on what the Minister mentioned before, and I'm still also waiting for a response from the Minister regarding my earlier question, whether when a court issues a warning, warning the offender of the possible consequences, whether that particular warning of the consequences of getting a warning will be given to the offender later on after the, for example, after the offender has served their sentence, because of the fact that, you know, after you've gone through the whole process, people might forget and potentially may need a reminder. So that is a clarification that if the Minister wouldn't mind giving. Now, when it comes to what the Minister said before, and this is specifically in relation to 86M, which now we're under, for me, I'm under the administration element of this, subclause 2. So 86M subclause 2. Now, although it says if the court is the court that first sentenced the offender, and if the court is not the court, they have to go back to a previous court. And this is what the Minister said before. I wanted to check with the Minister whether there's been any consideration of the potential court backlog around this, which is one of the concerns of some of the submitters, is the additional administrative burden. So if the Minister wouldn't mind just kind of clarifying whether she foresees that there will be an administrative burden, and or potentially that she has a rough estimate of how many cases this will entail, that'll be quite nice to have that reassurance. Now, the other thing that the Minister was talking about in terms of, and the other question I have is around 86N, which is around the notice of possible consequences and etc. And one of the things we brought up in the select committee, and we couldn't have a definite response from the officials, is around the fact that we do see a high level of dyslexia or neurodivergency within the whānau population, particularly with those who offend, on whether that has been a consideration given when a warning is issued to check in terms of the comprehension. Now, the Minister before mentioned quite a lot in terms of like, well, if you're this, then this doesn't count. If you're this, then this doesn't count. That is complex even by the standard of a legal expert, let alone someone who is offending or with dyslexia or neurodivergency. So my final question is whether the Minister has considered on how to ensure that offenders fully comprehend and understand that what they are doing and the warning and what that's going to entail. So yeah, so those are three questions: whether the warning of the consequences of warning will be given to the offender later on, clarification around the number of times or a number of instances that it will have to go back to a previous court under 86M2 subclause A and B, and also whether dyslexia and neurodivergency has been factored in when a warning is issued.
Mr. Chair.
The Honourable Nicole McKee.
Thank you for your questions there, the member from the Greens. In answer to those, we're not really worried about the backlogs. We are working on backlogs within the justice system. Part of the reason of having a 6-month implementation is to make sure that the system will be efficient when it goes through. When we're talking about or in answer to your question about how the warnings are given, as I just mentioned when I was last on my feet, that the warnings are given originally as an oral warning, face-to-face, followed up with a written warning. So there are two avenues there for a person to receive not only and understand the warning that is given to them, because it will be face-to-face, but also the written follow-up as well. So there will be no excuse for continuing to offend by saying that they did not understand that they had a warning in place, when it will be delivered in two ways.
Dr. Duncan Webb.
It's so good to be here. to give this the scrutiny that it deserves. I would just comment that last night the Minister did stand up and say we will be voting, and went through a number of amendment papers. I just thought it was a little disrespectful of the process of this House. She has one vote, she's a member of the Executive. She doesn't speak for the House of Representatives in which we sit today. But anyway, and the other point I'd make, which is in respect of my amendment paper I'm going to talk to now, is really reflective of the speech that the Minister just gave this morning, the first speech she gave, when she went through all of the complexities of this piece of legislation. Because what she has managed to develop through the original bill and through her amendment paper on the table and through the amendments she requested/demanded that the Select Committee take into board is one of the most complex and unworkable pieces of legislation I've seen, with differing strikes, having to go back and revive previous strikes, but not all of them, and even then sometimes in a different order. And then we've got section 86KA, which deals with the situation where someone has been given a first strike warning and then commits another offence and is sentenced to a period of imprisonment which meets the first strike test but not the second strike test. Now, we have a most bizarre, Kafka would be proud, a most bizarre situation where you get a second first warning. And I mean, that's a nonsense statement that you're on your first strike and you're sentenced and you get another warning. But it's not a second warning, it's a first warning. Now, I get what's trying to be addressed here. What's trying to be addressed is the risk that in respect of the first offence, there is an appeal against conviction or sentence which reduces the first offence to below the strikeable standard. And so you've got a kind of belt and braces, two first warnings, so that if one first warning falls away, you've still got a second warning. But it's absolutely a nonsense to give someone a second first warning. So that's why I propose the amendment, and essentially replacing the section to now make it and call it what it should be: new first strike warning where original warning cancelled. You don't give two first strike warnings because that's an impossibility and it just is a tortuous language. What you do is you wait and see. And if there is actually a change in the status of that first warning and it falls away, and then there is no warning. So you can give another warning which can properly be called a first strike warning. One of the problems here is that to give two warnings is actually really confusing. And it troubles me that sometimes our policymakers and drafters pride themselves on these really complicated so-called solutions, but we don't put ourselves in the shoes of the people who are affected by it. Now, I know the Minister doesn't really have a great deal of time for offenders and isn't concerned, but I'm actually concerned that we make it clear what's going on to them. And if they have two warnings, they're going to think they're on their second strike when they're not. So let's wait until the first warning is cancelled before we give them another first warning, and that's what my proposed section 86KA, new first strike warning where original warning cancelled, there's some simple language for you, Minister, would do. And so I would like her to revisit her statement that she is voting this amendment down.
The Honourable Nicole McKee.
Thank you, Mr. Speaker. I wonder whether or not the member is speaking to his amendment that was tabled this morning? Last night's one? Sorry, just checking. Okay. You know, that's all right, because I've already actually spoken to that, so I'm not prepared to speak to it again. But what I will say in relation to what the Speaker had asked, there is one point that I would really like to make, and that's in regard to the comments that were made about the policymakers and the drafters, of whom I have the utmost respect for the work that they do and the hours and time that they put in to make sure that we have right legislation that is fit for purpose, that looks after and addresses the community's concerns on public safety. And in that respect, I think that our policymakers and our drafters actually deserve a round of applause and a thanks for the work that they do.
Maria Meno Kapakingi.
Tēnā koe, Mr Chair, tēnā tātou katoa te whare. Just in closing last night, I did recall the Minister standing, Mr Chair, and speaking to, reading, which is not quite the same as speaking and thinking one's thoughts through oneself. So just reading off a paper and landing with the same old, I won't be dealing with this, I won't be voting it. I think it is more than a disrespect, it is a neglect on the Minister's part. So to that end, the Minister talked about rehabilitation. The assumption about rehabilitation is that there has been habilitation in the first place, which if you know what you're talking about on the subject, you will know that that is just not the case. It is a myth to suggest that rehabilitation can even occur when one doesn't truly understand and know the issues that exist in this context. So just to help you out, given my own training in this space, which it seems most have a gap of knowledge in this regard. The other thing that I do want to draw to the Minister's attention in my amendments, which of course clearly she regurgitated her boss's kōrero, which is, you know, Maoris and tiriti and all of that stuff has no place. I want to ask the Minister to explain whether she understands the concept of hohau te rongo. So that's referred to when I talk about, just to help her understand in English, restorative justice. The concept of that is a very old and important concept in action. That might be missing, it might be a gap of knowledge, but I can assure you what is now called restorative justice, which you should know, originates from family group conferencing, which originates from whānau hui, which originates from the Children and Young Persons and Their Families Act, 1989. So all of that work, that Māori intelligence and work, was provided to now the point in what the mainstream calls restorative justice, but the essence of it comes from hohau te rongo. So I'm curious that the Minister might know what that is, and I'd be interested that she see if she can explain that in the context of her rejecting outright amendments, which I know that her party think that way because sadly it shows up in their majority of racist rhetoric. Thank you.
A point of order, Cameron Luxton.
I think we can fairly take, well, I personally think that's a fair place to be taking offence when you hear someone say how that, when you're, that final comment from the member.
The point of order, Dr. Duncan Webb. I am just getting some advice on that.
Thank you, Mr. Chair. This House has explored allegations of racism and where they, the extent to which they can be made at some length in this House, and it's very clear that in terms of there's a convention that points of order are taken in silence.
Let's hear this point of order in silence, Dr. Duncan Webb.
And the fact is that it's well established that criticisms of policies and positions and legislation may be called racist, whereas allegations of that nature directed against a person are out of order, and that's a well established convention.
I'm going to just take some advice on this. My understanding that is that Dr. Duncan Webb's assessment is correct, but I am just getting some advice on that, and I would like to continue, and then we will come back to this. But I will ask members to focus their contributions on specific clauses. I've been going through the notes from last night, and there was a rich debate from what I can see, and a number of points have been raised, and there's a lot of analysis has been had, but I do want you to be specific to clauses and in terms of your responses to the Minister. I'll take the next call.
Mr Chair.
Honourable Nicole McKee.
Thank you, Mr Chair. To the member from the Māori Party, when I'm reading, especially when it comes to amendment papers or tabled papers which have no reference, are totally out of scope to this bill, I will ensure that I do read, because from this position it is important that we are accurate and have our wording correct. So there is a need, when there are a number of amendment papers, to make sure that we address the paper itself and what it is that needs to be read out, so the member understands that they are well out of scope and should probably look to the bill and how the bill is read in itself. In regard to rehabilitation, as I had mentioned last night in one of my speeches, the rehabilitation is still available to prisoners, including education. So I'm not quite sure what the member is on there. And in regard to the debate that member keeps bringing up, saying that the party or the government is racist, I think what the member needs to do is have a look at the bill and realise that the bill is not based on race. The bill is based on bad behaviour. The bill is based on those that create the most serious, violent and sexual crimes, not on race.
Taihoa. I don't want people talking to each other across the chamber. So I do want that to stop. And just to the point of order and the counterpoint of order in terms of what can or cannot be said in terms of referring to something racist, you are able to infer things to the government or to policies, but not to an individual person. When we're talking about rhetoric, that can be something that could relate to the government or to an individual, so it's incredibly contextual. So if I could ask members to refrain from using those terms, that term in terms of the way that it might relate to the individual, that will help in the order of the House. And also, I do want to hear specific interventions on clauses. Dr. Lawrence Zudan.
Thank you, Mr. Chair. So just seeking also some clarification from you, Mr. Chair. It might just be that I'm still quite new, but I didn't think that the Minister was able to consider herself what amendment papers is in or out of scope. But just would like some of the clarification. And also in terms of one of the things and the reason why we're coming back to rehabilitation, coming back to talking about this again, is that we still haven't heard from the Minister yesterday, and I think multiple members asked this and we didn't hear a response, is how is the Minister going to address the fact that under the old system, 81% of people who received third strike were Māori, and which is disproportionate to their population. So what are we going to do that? But going to the specific point that the Honourable Dr. Duncan Webb mentioned before, in terms of having 2 first warnings, we're still waiting to hear a response from the Minister regarding that. I want to point to a specific clause where that may affect, which is 86U, subclause 2. Now, in this particular clause, it talks about an offender ceased to have a record of first warning in relation to stage 1 offence, or record of subsequent warning in relation to a stage 2 or 3 offence. But as we see from the new section KA, you can have a first warning in a stage 2 offence. So if you can have a second first warning during the stage 2 offence stage, but this clause only addresses subsequent warning in stage 2 clauses, but doesn't address first warning in a stage 2 clause. What happens when a person has a first warning at a stage 2 level? Because does then that it means 86U2 no longer applies to them? And what happens to these people if it is no longer applicable? And one other thing I want to just really touch on in terms of what the minister said before, and I do appreciate the minister responding to my earlier questions, particularly around ensuring that the offenders do get an oral and a written warning. But one of the things I would like to point out is that also makes assumption on the comprehension of the oral and also on the written warning. And my question was very specific, and I have been listening to the minister very carefully. Will they check to see if the offender comprehended and understood fully what that warning means rather than just delivering oral warning and written warning? So again, just for clarity, my questions was around how is the minister going to ensure that this time round we're not going to be seeing an overwhelming number of Māori who are going through the strike system like we've seen it earlier, that is disproportionate to the population, around what happens in 86U subclause 2 when a person has a second first warning but is applicable in the stage 2 stage but is not referenced in this particular clause as an example. And my last question is checking on the comprehension of the warning and whether the warning will be understood. Thank you.
Thank you. Just in terms of the clarification that was sought, I will be determining what is or isn't in scope, but also noting that the minister has in her interventions and her contributions address certain issues. So I am listening carefully to see whether issues have been addressed or not. James Mager.
Chair. I wanted to address the points made around the minister not supporting particular amendments, which we have covered off in a lot of detail. And I remind Dr. Webb that last night we indicated that we also didn't support the amendments, and I've checked with my colleagues in the ACT Party New Zealand First, and they won't be supporting the amendments either. So just to give Dr. Webb some assurance that this side of the House won't be supporting the amendments the minister has already well and truly covered off. And also, I'll give the minister a chance to address Dr. Webb's tabled amendment from this morning, whether or not the minister can indicate she thinks that amendment should be supported. I have reviewed it and I didn't think it was one that we would support, and I want to get the minister's view on that as well. It's good that Dr. Webb spent some time doing some homework last night. I also did some homework. I spent a good couple of hours after the session last night just reviewing what we'd gone through, because I was wanting to come to the House this morning and make some substantive contributions on the clauses in the bill that haven't actually been covered off. And of course we had Dr. Shunan yesterday covering off clause 3 around inconsistencies and his questions around permanent records, and Dr. Webb also touched on the manifestly unjust provisions in 5 and 6, and then both of Dr. Webb and Dr. Shunan and members, and also Ginny Anderson, then spoke at length on clause 7, which is the operative clause around how the three-strike system works. And then of course the minister this morning gave a very fulsome answer to that, and I wanted to thank the minister for providing, I think, some quite detailed answers to questions. Some of the calls are quite long, and I found it hard to discern the questions from them, because over 5 minutes it's hard to find where the questions have come from. So hopefully the shorter and sharper the calls, the more detail we can extract, and obviously the chair does a great job at picking out where the questions are, and that's why he's in the chair and we sit over here on the benches. And I just wanted the points, the new material I wanted to raise was, given that we have covered off all the trajectory, all the material in clause 7, it's just heading now towards clauses 11 and 12. And just to get the minister's confirmation that my understanding is correct, in that clause 11 inserts amends actually schedule 1AA, and that is to do with the reactivation of previous strikes, which Dr. Webb covered off last night in quite a amount of detail, and clause 12, which inserts new schedule 1AB in schedule 2, and that of course lists the qualifying offences that will be provided in this scheme, which Dr Webb also covered off in quite an amount of detail last night. So if I can just get the Minister's confirmation that that's my understanding of how those two clauses operate, and that the Minister's comfortable that she addressed the questions in those schedules posed by Dr Webb last night, and then I'm very much looking forward to continuing on into part 2 very shortly.
Mr Chair.
The Honourable Nicole McKee.
Thank you, Mr Chair. There's a bit there for me to unpack, so please bear with me. I'm going to start with the Green member's contribution and see if I can clarify again in a way that is more helpful to the member. In regard to 86U, clause 86U, subsection 2, the questions that the member asked me is actually covered by section 86U, subsection 2A. It covers the additional first warnings under section 86KA. In regard to rewarning people after they have left prison, the intention is not to do that, but I can assure the member that should a person be in prison and they commit another crime, they're likely to receive another warning and they'll be told about it again at that stage. In regard to the court impacts as well, which the member had mentioned, in 86M subsection 2 is the reference that I will give you. It will be infrequent that a person will have to go back to court, but there will be a few cases expected. It could be where the court omits to give the warning, and judicial education and the 6-month preparation for the implementation of this law will help with that, because that's where the training of court staff and the judiciary will be undertaken. So there, of course, will be the other exception where, say, a person appeals a decision to the Court of Appeal. It is usual, not the only way that it occurs, but often a judgment is reserved and delivered later. Therefore, the offender is not always in court at that time. This means that the offender will have to go back to the original court in order to receive the sentence or the warning, or, if the case may be, have the warning removed. But it will need to be done face-to-face, and a person will need to be recalled if the appeal is successful or not. The warnings will be communicated to the offender, and the court can use whatever words that they wish to use to be able to help that individual understand what's happening. So it's not like they'll be reading from a script. They'll actually be able to understand the scenario that that individual will be in.
Jason McCallum.
Mr Chair. Thank you, Mr Chair, and thank you, fellow members. Thank you, members from across the House, for taking the opportunity to summarise and school us on what we should and should not be asking, or what we should or should not have comprehended from what the Minister has chosen to answer to date. Whilst the members from across the House may think that the questions have been well traversed and well answered, they're as clear as mud in some cases, so they will continue to be asked. The Minister has said that the whole purpose of this bill is to provide a consistent and certain consequence, which I think is a little bit ironic given the state of affairs in this committee of the whole House stage, where we have preemptive explanation and splaining going on, where we have a Minister refusing essentially to engage in some debate and arbitrarily just ruling it out of scope if it doesn't suit her purposes. But I've still got some genuine questions, because I don't understand the logistics of how some of this is going to work. When the Minister says, for instance, that the offenders will have, well, the people who are going to get the strikees will have received and therefore understood a warning, there's a huge assumption, and the word understood is doing a lot of heavy lifting there. It's not okay for a Minister to sit in the chair and just say that the court staff, after a brief period of 6 months of preparation, in which time all of the IT, all of the training, there's an awful lot going on in a 6-month period, to have logistical preparation for an efficient and effective system to be carried out. And during that period of time, they're able to use some words, and therefore people will understand. my colleague from the Green Party asked some legitimate questions about individuals' capacity to have sufficient understanding to understand what is an incredibly complex warning system. Having sat through the select committee process and having the opportunity to ask experts, officials, direct, robust questions about stepping us through the complexity of this, sometimes the answers provided made it less clear rather than more clear. So you can only imagine standing in a courtroom being told that you're getting a first warning about something. So what I really want to know is, whilst an awful lot of work has gone into amending and rewriting and all of the focus has been from the impetus of the court or the minister or the party in the legislation, what work has gone into ensuring that there actually is some understanding or testing understanding? You know, do people leave the courtroom and have to sign something to say that they understood? What happens when an oral warning is given and then it's assumedly written, backed up by a written confirmation? If one or t'other doesn't happen, how does that impact on the one that does? I agree with my colleague, the Honourable Dr. Duncan Webb, that there's torturous language throughout this and high anxiety in the context in which all of this is supposed to actually operate on the ground. Yeah. So I think there are still questions that need to be asked and still questions that need to be answered without flippancy, as if the questions are an inconvenience or as if they are on purpose being silly to slow proceedings, because they're not. This whole process has been fraught with misunderstanding, and this is the only chance we get now, whilst the rest of it happens during urgency, to actually ask those questions. Some of us would prefer, we didn't choose to introduce this horrible bill, but some of us would prefer that it at least went out in as good a shape as possible on our watch. So I don't begrudge the fact that we're able to ask questions. One of the things that, again, remains completely unanswered is going back to 82A insofar as the repeated must not be taken. The additional consequences for certain repeated offending must not be taken into account in determining length of sentence. And as was mentioned last night, but not sufficiently answered, it's that sentence in and itself does a lot of heavy lifting. It's absolutely assuming that because it's written down somewhere, therefore that will occur. You can't unknow what you don't unknow. It's like asking someone not to think of polar bears, and then of course that's all they can think of. There are means by which in other fields...
Mr. Chair. Thank you, Mr. Chair. Mr. Chair, I'm just going to carry on with my answers to the questions that James Meagher had asked me in regard to clauses 11 and clause 12, which relate to Schedule 1 and Schedule 2 of the bill. Schedule 1, or Clause 11, is relating to the old regime, and it's providing definitions to clarify that offending under the old regime does not use the definitions of the stages 2 and 3 offences in the new regime. And in Schedule 2 for Clause 12, there is a list of the qualifying offences which have been increased by 2. So it has moved from 40 to 2. And it is outlining those qualifying offences which are deemed to be some of the most serious, violent and sexual offences that a person could commit. And of course, every single one of those is punishable by imprisonment of over 7 years, and that's why they are included. It also assists with the lower level offending that was caught up in the last regime that we do not want carried over into this new regime. In regard to the member's question about the amendment paper that was tabled this morning at 8:46 a.m. by Duncan Webb, I will not be supporting that paper. I will take note that there is a 6-month commencement period in order for the courts and judiciary to prepare for implementation. As I mentioned last night, the Ministry of Justice operational staff are working on ways to ensure that the offenders are aware of how they are affected by carrying over those previous strikes. Of course, this will have some logistical and privacy issues for those individuals, which is why it's important that we do have that 6-month implementation.
Tom Rutherford.
This question now closed.
Dr. Duncan Webb.
Yes, my Green colleague did have a turn just before, and I've got a number of amendment papers that I haven't got to, including the one the Minister just alluded to. And unlike Mr Meagher, I didn't stay up late last night. I got a jolly good night's sleep, and so I'm here ready to go. So, in respect of my proposed new section 86LA, this goes to the deterrence effect. Because the Minister's retrospectively reviving former strikes, and yet, I mean, the former the offenders who had those strikes and will again have those strikes won't know about it. And if the purpose of this bill is premised on the assertion, flawed though it is, that if people know the consequences for further offending are greater, they are less likely to commit that offending. That's the theory underpinning, that's the fundamental theory underpinning this. If that's the theory, then you've got to tell the people who are affected that the consequences of further offending are greater than the norm. They are disproportionate, to use the words of Paul Goldsmith. So my proposal is that the people who are having their strikes revived, if you like, reinstated, are told that that is the case. They are informed in writing, because that's the only way the whole theory can actually work. Otherwise, they're subject to, and there's a kind of natural justice issue in here as well, isn't it? They're subject to something, a change, which they have no knowledge of, and if they don't have any knowledge of, it clearly can't affect their behaviour. So that's that paper that was tabled today, although I prepared it yesterday afternoon just for James Meagher's goody two-shoes benefit. And then the other amendment paper that I've got there, and I'd be interested in the Minister talking about this, because it's actually quite an interesting point. Throughout the bill, it talks about recalling an offender to the court if the sentence was imposed at a time they were not in court. Now, I find that very unusual, because by definition, it's a sentence of imprisonment that is being imposed. And I'm perplexed as to the circumstances in which a person is sentenced to imprisonment and isn't before the court. And I would have certainly thought that in those cases that you shouldn't be sentencing someone to prison unless they're there in front of you. Now, it may be, and I know the Minister's keen, and in fact she's had the cooperation to a large degree of this side of the House on AVL to assist some of the court backlogs, and it may be that's an allusion to the fact that there's conceivably situations where there's sentencing by AVL and you actually want it to be genuinely face-to-face, not across AVL. But my amendment paper that was filed at 12:48 p.m. yesterday actually addresses that, because I do think that if you're going to sentence someone to prison for a strikeable offence, then they should be in front of you, and it shouldn't be a case that you sentence them in their absence, which seems bizarre to me, and then you get them back. And that's the other thing in terms of getting them back. To summons, you've just sentenced someone to imprisonment, and then you're issuing a summons, or stage 2, a warrant for their arrest, but you've just sentenced them to imprisonment. And this is the kind of gobbledygook that is throughout this piece of legislation, which makes it very hard to follow. And I'm really concerned, as my colleague Ginny Anderson said, in practical terms, is it workable? But very interested in those two things. You'll see I've done two of my amendment papers in one hit. The one being the notification of strikes, and the other one, the offender being before the court at the time of the sentencing and warning.
Tom Rutherford. Yeah.
I move that debate on this question now close.
Dr. Lawrence Zunan.
Chair, I want to thank the Minister for answering my previous question, and I want to point to a new section that I haven't spoken to in the committee stage yet, which is section 86V, around how cessation of record affect later sentences. Now, my question to the Minister is a point of clarification. Now, in 86V, subsection 2, 2A and 2B, it makes references to what an appropriate court is, despite the fact that we see the mentioning of appropriate court in 86U5. But I was curious to know, particularly around why 86V2A came about, because I wasn't actually part of the select committee stage when this was being discussed, where 86V2 mentions High Court, 2A mentions High Court, or if it's not the High Court, but by a higher court, and then 2B is District Court. I guess the question is, why separate High Court out from not High Court and from District Court? Because presumably, if you don't have 2A, because the rest of A and B is exactly the same, presumably if you have 2, just to say High Court and above, it would cover both 2 and 2A off quite nicely. Because presumably, my understanding is that you get High Court, you get Court of Appeal, you get Supreme Court, and below High Court, you have District Court. What I wanted to check is, does 2A in fact factor in another court that would have this power that is beyond the current higher courts of District, High, Court of Appeal, and Supreme? And if it doesn't, wouldn't it be better and less confusing or convoluted to have 2 and 2A together?
Todd Stevenson.
Mr. Chair,
Todd Stevenson.
I move that debate on this now close.
The Honourable Dr. Duncan Webb.
Mr. Chair, I think we're almost a quarter of the way through my amendment papers. The next amendment paper I'd like to talk about is the one filed at 12:46 p.m. And that relates to, on reflection, this is the summons to an offender to attend to get their warning. And I must say, if you put yourself, if you can, in that situation, you've just been sentenced to 12 months in prison, you've been on remand for 14 months, so you walk out the door with time served, and then they forgot to give you your warning whilst you were in prison, whilst you were before the court, and then you get a summons. Now, you're not going to be over the moon about that, right? And there is a challenge there. Because a lot of these people may be distant. They may have been convicted in a court which is in a different city, because there's this rule that you've got to go to your sentencing court, right, in a different city from where you're actually living. So whilst if you are arrested, the constabulary will no doubt assist you with your transport needs, that's not the ideal solution. And so my amendment paper notes or suggests that where there is a warrant, a summons, not a warrant, a summons, then the offender should be given all necessary assistance, including travel by the most convenient means. And that's not a paddy wagon, that would be an aircraft if it's a long distance, because they've got to get there, right? And certainly if a witness is summoned to the court, the person summoning them has the obligation to pay the travel costs. So I think that's actually a really important thing, because these are people for whom travel is often not easy. It's not going to be easy to, even if it's just to get into court in Wellington from Upper Hutt, it's still a challenge. So that's that amendment paper. And the next amendment paper I'd like to talk about is the one filed at 12:45 p.m. Because this again relates to warnings not being given at the time. And as it currently stands, Section 86M provides that the court can essentially go back and give that warning indefinitely. And so they forget, and this is the point Ginny Anderson made about, the court systems not being good. We know they're struggling in there. They don't give the warning. 2 years pass, and then they're like, oops, let's recall this person so we can give this warning. Well, that kind of oversight isn't acceptable, and there has to be a time which is no longer reasonable. So my proposed amendment inserts a new subsection 3C, and it simply says that in no circumstances is a warning to be administered more than 6 months after the offender has been sentenced. So it gives a grace period, which I think is quite reasonable, but if the court hasn't got its stuff together within that 6 months, you don't have this hanging over your head indefinitely. There is a situation where you could get 2 warnings late, right? So all of a sudden the court realises they've missed a warning, and then they go back and look, see, they've missed 2 warnings. So you go from 0 warnings to being on your 3rd strike. That would be outrageous and entirely undermine the purpose of this bill, which is actually to let people know the consequences of further serious offending. So that's that amendment, and I'm trying to get through them because I know that the kids on the other side are getting a little bit grumpy. Because I'm still on warnings. I'm still on warnings because
it's a bit early.
The next amendment paper, filed at 12:49 p.m. yesterday, and the Minister said something that I was quite concerned about in relation to warnings, and that was that the judge can use any words they like, because this is really important that the warning is clearly expressed. And so in that situation, what we need...
the member's
Mr. Chair?
has expired. The Honourable Nicole McKee.
Thank you, Mr. Chair. Just would like to address the Green members' questions about clauses 86V 2A, or 86V and 2A. 86V 2A allows the appeal courts to take the necessary actions if they feel that that is appropriate. And 86V subclause 2B is also reflecting that in some cases the district court may have taken the actions relating to the earlier warning ceasing, while the later qualifying sentence may relate to an offence that the district court does not have jurisdiction to deal with. So, for example, if the latter sentence was for murder or a stage 3 offence that required the High Court or above to deal with it. So a category 3 or category 4 offence must be heard in the higher courts, whereas categories 1 and 2 are heard in the district courts. When it comes to the Honourable Duncan Webb's amendments, I feel that I have addressed all of those yesterday evening, and I stick by what I said at that stage.
Before I take the next contribution, in terms of the amendment papers that were Many of the amendment papers that were filed, that were discussed last night, my understanding, just going through some of the notes, that many of those have been addressed. And so the way forward would be, for me and for the House, would be that if you're referencing those, that you preface your remarks with a question. So a question in particular that the Minister has not addressed. Of course, there are other amendments on the tables. Point of order, Dr. Duncan-Webb.
For your guidance on that. I do think it's really important that this is a House for debate, and whilst I accept that there's a question and answer aspect to what goes on under the more recent convention, what the Minister has done is stand up and say, in pretty cursory terms in many cases, I don't like that, I won't be supporting that, and so on. There is an entitlement to speak to amendment papers, including of other members, to make the case that the Minister should adopt them. And the Minister can't preemptively say that's not the case because I'm not supporting it anyway. I just want to make sure that that's not, you didn't suggest that from the curve.
That would be correct. That is my understanding, but I'm sure you'll be able to preface your comments with questions which would help to illuminate the House. Dr. Lawrence Unan.
Thank you, Mr. Chair. And also thank you for the Minister for the response to 86V. That was very helpful and actually was very clear. And I would like to discuss a new section, and this is section 10, which I believe have not, particularly this section, have not been discussed. And I know that some of the other members, and particularly some of the government members, have discussed 11 and 12. But I want to specifically focus on 10, and in terms of the list of circumstances under 1A. And understandably, under section 10, subsection 1A, those circumstances, I believe, are some of the most concerning that we do see in our communities, but particularly from the perspective of premeditation. But I'm wanting to specifically ask the Minister some questions around 1AJ with regards to any other exceptional circumstances that exist. And I want to check with the Minister whether the Minister would consider hate crime as one of the criteria within this particular list. Now, for my community, for the ethnic communities, and for migrants of color, for Pacifica, for groups with certain religious affiliation, it could be any religious affiliation, the idea of hate crime or violence or even murder as a result of hate crime is a significant factor, and it may not meet the threshold of what you see in 1AF in terms of being committed as part of a terrorist act, which we know very well. But I wanted to check if specifically in the context of hate crime, it would be something that the Minister would be open to as part of the exceptional circumstances that exist beyond what is listed here in section 10, subsection 1A.
Mr. Chair.
The Honourable Nicole McKee.
Mr. Chair, thank you for that question. There is no law on hate crime as such right now, but what we do have are 42 qualifying offences. And one would think that in exceptional circumstances where one would think it is hate crime, it would actually, if it's a serious violent crime, it would come under the auspices of one of the 42 serious offences that are already there. We do not have a reference to hate crime as such in our legislation, so therefore we will be sticking to the 42 offences listed in Schedule 1.
Mr. Chair. Commander Bellich.
Thank you, Mr. Chair. I haven't had the opportunity to take a call on this bill, and so I thought I would do that, seeing as I was listening to the debate last night and also this morning. And I didn't have the opportunity to take part in the select committee that considered this bill, but it's not one that I don't think anyone in the House is unfamiliar with because of the history of 3 strikes and the politicisation of this particular piece of criminal law in terms of the way that it's being implemented. And I do have some questions for the Minister specifically in relation to the sections in Part 1, but just for context, I wanted to prepare for my contribution, as I hadn't been in the Select Committee, to make sure that my comments were relevant to the debate and also relevant to the discussions that had gone on by a number of other people. And I was struck really by the report from the Select Committee, especially in relation to the number of parties who disagreed with the Minister's approach, and that is a question that I want to ask the Minister, and the reason it's relevant to Part 1 is because Part 1 is the operative part of this bill, which essentially sets in place the new change in relation to the three strikes bill. And so just to briefly put into context for the Minister before I go to my questions, the Ministry of Justice, in fact, didn't think that there was a lot of evidence for introducing this bill and said they preferred the status quo. The Children's Commissioner opposed the bill. The New Zealand Bar Association opposed the bill. The Law Society opposed the bill. The Pacific Lawyers Association opposed the bill. The Human Rights Commission opposed the bill. Te Huinga-Roia Māori o Aotearoa opposed the bill. The Law Association opposed the bill. So there is a significant amount of opposition to this bill, and it is based on the evidence, Minister, from my assessment of this legislation, this proposed legislation, that it actually doesn't work in furthering the passionate objectives that she has put forward in this committee stage, in the sense of making sure that violent offenders are not on the streets. And I'm sure everyone in the House agrees that people should not, who are a danger to society, should not be out on the streets. But it appears that the experts in this field that participated in the Select Committee process do not agree with her assessment. And we have traversed the reason for an even worse change, in my view, the retrospectivity change that takes into account previous warnings. And she said she'd received, and I think we've had it agreed, but she may want to comment on this, at least 3 emails on that point. So if there is this weight of opinion against this bill, which is operative in Part 1, what and who is she relying on to make sure her ambitions and her noble objectives of keeping New Zealanders safe will actually be furthered by this bill? And did she consider, in fact, looking and talking to some of those organisations who did participate in the Select Committee process to ask them what they believe would actually keep New Zealanders safe, as opposed to bringing back a piece of legislation that doesn't work based on evidence, based on independent assessment, and based on the fact that there is very little evidence worldwide that more serious sanctions result in fewer pieces of offending. And that is something that is a principle that has been looked at worldwide and with many different, more harsh penalties than this. And so that is an overall question that I have for the Minister in relation to Part 1, and I wondered if she could address that. And I also wanted to ask her, when there is a warning put in place, and when she has put in a complicated regime where the manifestly unjust provision can be taken into account by the judge, what in her mind is evidence that suggests that judges are not able to make that assessment currently when imposing a sentence? Because as she has outlined in Part 1 in the proposed 86T section of this bill, there is a provision here for it to be manifestly unjust. Now, I think we have an excellent, impartial judiciary in New Zealand. I think they get out of bed every day and they do a hard job and they do the best job that they can. And my view from what I've seen of the criminal law, and I'm not as experienced as some members in this House, but from what I've seen, they do a fantastic job at weighing all the evidence, and I wanted to know the Minister's response.
The Honourable Minister.
Thank you, Mr. Chair. In relation to the last member's comments, there were 749 submissions, of which 188 submitters were opposed to the bill. And the member listed off quite a number of them. However, there were 515 submitters who either supported the bill or they didn't support the bill because they wanted the bill to be harsher and therefore wanted it gone so that they could have an even stronger bill, including reinstating 3 strikes as it was in its old regime. And in regard to Section 86T, I did speak to that extensively this morning.
Vanessa Winnick.
Move that debate on this question now close.
Brand new points still on their wrapping paper.
Yes, and what I propose to do with the Chair's...
Honourable Dr Duncan Webb.
Yes, thank you, Mr Chair. What I propose to do is to go through these amendment papers pretty quickly. I could do them one at a time in a couple of minutes, but I propose to just see how many I can get through, and then the Minister can respond to them. Because the one I want to start with is it's about the centrepiece of this legislation, which is the warning itself. And I was about to say, before I was sat down before, that I'm concerned that judges aren't giving guidance as to what the warning should be, because the understanding on the part of the offender is the critical point of this piece of legislation. And so my suggested amendment in clause 86M is to insert a clause which says this: the Attorney General, and the Minister might think someone else would be better, but I thought the Attorney General was not bad, may provide wordings for warnings administered under this Act. Where the words are used in making a warning, this warning is irrebuttably presumed to be accurate and clear for the purposes of the preceding section. So it's basically a safe harbour. Use these words and, you know, they're considered irrebuttably. Now, you can use other words if you want, but if you do that, if you get it wrong, if you stumble over your words, or even if it's just not clear, then you run that risk, because that ties in with the next amendment paper, timed at 12:50 p.m, which inserts a new subsection 6A into the same section, which says this: in the event that the warning is not accurate or did not accurately communicate the possible consequences if the offender received a further qualifying sentence, then the warning is of no effect. And that is actually really important. And I guess my question to the Minister is this, and I think the Minister can actually add meaningfully to the operation of this Act in answering this: is it her view that if a warning is administered in a way which is in some way not accurate, or is communicated in a confusing or complex manner, even though it's technically accurate, does she agree that that warning will be of no effect? Because, and that will, in this House, we inform the way the judges apply the law. And so that question and answer is actually an important one. If there is an error, and it's got 2 parts. If there is an error in the warning, is the warning of no effect? If the warning is not comprehensible to the offender, is the warning of no effect? And I see that your officials are assisting you, and it would be good to get an answer to that.
Mr. Chair. Catherine Wedd.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
ACT New Zealand. New Zealand First.
In favour.
Te Pāti Māori.
No ngā pōti e whakahe ana.
Sorry, my thing fell out of my ear. Te Pāti Māori.
Ka whai. E ono ngā pōti e whakahe. Thank you.
The ayes are 68, the noes are 43. The question is agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 4.2 be agreed to. Those in favour say aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
2 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti e whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to the deleted clause 4.2 and amend clause 7, new section 86K 2B be agreed to. All those in favour say aye. Aye. The contrary, no. No. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
Votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
O e whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. Maria Mino Kapakingi's tabled amendment inserting new clause 4A is out of order as being outside the scope of the bill. The question is that Dr Lawrence Zunan's tabled amendment to delete clause 5 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono e whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to new subsection 2 of clause 5 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono e whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to clause 6, new section 82A1 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it.
Ayes have it. Party vote.
Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono e whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Maria Mino Kapakingi's tabled amendment to clause 6, inserting new section 82A1A, requiring courts to consider the potential for disproportionate impacts on Māori offenders, be agreed to. All those in favour say aye. No. To the contrary, no. No. Noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
Opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
E ono e tino whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Maria Mino Kapakingi's tabled amendments to Clause 6, inserting new Section 82A 1A, requiring courts to give consideration to tikanga Māori-based restorative justice, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
Whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 6, inserting new subsection 3 into new Section 82A, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
Opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
E ono e whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendments to Clause 7, new Section 86J, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakai.
Act New Zealand.
11 opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, replacing 18 with 25, a new Section 86J, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
Opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, replacing 12 with 24 and 24 with 36, a new Section 86J, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, deleting text from the definitions of record of first warning and record of subsequent warnings in new Section 86J, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
I'd opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, inserting physical into the definitions of record of first warning and record of subsequent warnings in new Section 86J, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, amending new section 86K and 86M to specify that warnings must be given in person, be agreed to. All those in favour say aye.
Aye.
To the contrary, no. The noes have it.
Ayes have it, party vote.
Party vote is called for. Please conduct a party vote.
New Zealand National.
49 opposed.
New Zealand Labour.
22 votes in
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, amending section 86K and 86L to add the word determinant or determinate, be agreed to. All those in favour say aye. To the contrary, no. The noes have it.
Ayes have it, party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, deleting new section 86KA, 86U2A and 86U2B, be agreed to. All those in favour say aye.
Aye.
To the contrary, no. The noes have it.
Ayes have it, party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to replace new section 86KA be agreed to. All those in favour say aye.
Aye.
To the contrary, no. The noes have it.
Ayes have it, party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, amending new section 86L to remove reference to Stage 3 offences, be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it.
Ayes have it, party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7, inserting new section 86LA, be agreed to. All those in favour say aye. Aye. To the contrary, no. Noes have it.
Ayes have it, party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, amending new section 86M1 to replace that with the, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it.
Ayes have it. Party vote.
Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to remove the words "if the offender is before the court at that time" in Clause 7, new section 86M be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert paragraph C into the new section 86M2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it.
Ayes have it. Party vote.
Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert paragraph D into new section 86M2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it.
Ayes have it. Party vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Zunan's tabled amendment to Clause 7, amending new section 86M3AA to replace 12 with 24 and 24 with 36 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert paragraph C into new section 86M3B be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it.
Ayes have it. Party vote.
New Zealand.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed.
question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert subsection 3C into new section 86M be agreed. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new section 86M5 to require a judge to check that offenders understand the nature and consequences of warnings be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote. Party vote has been called for. Please, Clerk.
Sorry, which one did you just read out?
This one.
This one here? All right, sorry, yeah, I've got it. Thank you. New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert subsection 6 into new section 86M be agreed to. All those in favour say aye. Aye. To the contrary, no. No. Noes have it. Ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakae.
The ayes are 43, the noes are 68. The motion is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert subsection 6A into new section 86M be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to replace subsection 3 in new section 86N be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
Right, yes, e ono ngā poti whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's remaining tabled amendment to Clause 7, new section 86N be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakae.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new section 86N3 to delete paragraph B, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new section 86O to replace 24 with 36, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote call for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti tino whakai.
The ayes are 43, the noes... the ayes are 43, the noes are 68. The question is not agreed. Dr Lawrence Yunan's tabled amendments to Clause 7, deleting new section 86O2 and 86R3 are out of order as being contrary to the objects and principles of the bill. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert subsection 5 into new section 86O be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote call for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7 replacing new section 86P2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote call for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
Opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7, new section 86R be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new section 86R6A to replace 2 with 3, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā poti whakai ana.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new section 86S2 to replace 18 with 12 and 20 with 17 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7, new Section 86T be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new Section 86T2C and inserting paragraph D be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert paragraph D into new Section 86T2 be agreed to. All of those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert new Section 86UA be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new Section 86V be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, amending new Section 86X to delete subsection 2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Action New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
E ono ngā pōti I whakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Maria Mino Kapakingi's tabled amendment to Clause 7 inserting new Section 86XY relating to treaty impact statements be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
was in order.
Wow, okay, ono ngā poti tino whakai, kia ora tātou.
The ayes are 43, the noes are 68. The question is not agreed. Just would like to remind members across the House that we vote in silence. We need to hear what's being said. We know some of these amendments are tensionable, but let's just move on in silence with the voting. Thank you. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert new section 86Y be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
He ono ngā poti wakaai. Wakaai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 7, inserting a new section 86Y be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
He waru, he ono ngā poti wakaai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 7 to insert new section 86Z be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
He ono ngā poti wakaai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Part 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa New Zealand.
Te kaumarima ngā poti whakahē.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
He ono ngā poti wakae.
The ayes are 68, the noes are 43. The question is agreed. Members, we come now to Part 2. Part 2 is the debate on Clauses 13 to 23, amendments to other acts, and Schedules 2A and 3. The question is that Part 2 stand part. Tom Rutherford.
Thank you very much, Madam Chair. I'll just take a quick call here. Looking at the amendments proposed by my colleague Dr Lawrence Yunnan into Part 2, one's relating to Clause 14, one relating to Clause 16. Keen to understand from the Minister around whether or not she'll be supporting those amendments and the rationale as to whether or not she will be or not, and then keen to move to the more substantive parts of the legislation that will be progressing. Thank you.
Honourable Nicole McKee.
Thank you to the member Tom Rutherford for his question. I did preempt this a bit last night and actually went through these when we were actually on Part 1, so I'll repeat what I said yesterday evening. In relation to tabled amendment from the Green Party member, which I will call 5:17 p.m. It's in relation to Clause 7, deleting Clauses 20, 21 and 22. I do not agree with that member's position. I believe that offenders should face serious consequences for repeat offending, and just a reminder that there is a manifestly unjust exception within the bill to assist. In relation to the tabled amendment 525 PM, clause 14, replacing subclause 4B with another subclause. Again, I do not feel that this is necessary. This is adding items to the list that have already been covered. Therefore, I will not be supporting that either.
Dr. Lawrence Yunnan.
Thank you, Madam Chair. And thank you for that explanation before as well. But I think I want to start again for part 2 methodologically. And I want to start with clause 14, and I'll come to clause 16 a little bit later. Now, in terms of clause 14, I want to get some clarification from the Minister in terms of the definition for sentence, and this is the amendment to the Criminal Procedures Act. And I know that we talked about the Criminal Procedures Act before in the context of what is considered a permanent court record, but I think in this case what we're seeing is that sentence here for 14 subsection 4A, that makes sense, that's fine. But I'm looking at 14 subsection 4B, and this is the part that I want clarification, because it says that sentence includes a record of first warning and a record of subsequent warning, not or. And I wanted to kind of check that in this case, does the Minister consider that a sentence will only be considered or is only defined when you have both first warning and subsequent warning? And this is one of my amendment papers, amendment paper, I don't know what timestamp it is, but it is the one that amends this particular clause, and which is just separating out these two particular clauses to specify that these two, first warning and record of subsequent warning, is in fact mutually exclusive. And I think another point I want to kind of check with the Minister is, again, when we're looking at the use of and or in this case, if you're looking at the example of clause 18, and this is the Amendment to Evidence Act 2006, it says before section 139 subsection 1C, insert BA, subsection BA. And in this case, it indeed used a record of first warning or a record of subsequent warning instead of and. So I guess the clarification I need from the Minister is 14B requiring both, or are they mutually exclusive? And if they indeed are mutually exclusive, will the Minister consider my amendment?
Honourable Nicole McKee.
Thank you to that member. I did just say that I did just speak to the member's amendment paper, which is 525 PM, which speaks specifically to clause 14, 4B, and the insertion that the member was wanting to make, which I thought was unnecessary. This is a technical portion of the bill, the subpart 2, and really the clause 14 is looking at the definition of sentence in section 184. It's amended to include records of first warning and subsequent warnings, including the giving and the recording of those warnings, as well as orders which could be issued under the new 3 strikes regime. And while I'm on my feet, I realised I had missed out tabled amendment 526 PM of the members, which relates to clause 16, subclause 6, and an insertion that the member wishes to make. I will not be supporting that tabled amendment. The court already has the discretion in being able to decide about what is a qualifying sentence, and we're happy with that provision.
Honourable Dr. Duncan Webb.
Chair, I have a couple of, and so a lot of this part is in some ways administrative, but I do have 2 things I want to ask. And to be fair, it's simply around the complexity of this legislation and how it interacts, and that's in respect of the Criminal Procedure Mentally Impaired Persons Act, and also a bit later on, if I get to it, the Parole Act. Section 16 which amends Section 34 of the Criminal Procedure Mentally Impaired Persons Act, inserts into Section 34 an additional provision. Section 34 provides the power of the court to commit an offender to hospital or a facility. Obviously, and this is for mental health reasons. And, I think in this House we all accept, we don't agree on this bill, but we accept that where offenders and prisoners have mental health and other issues, that part of the correction system is to address that. I may have this wrong, but I'm just a little concerned that the proposed insertion provides that no order may be made under subsection 1B in respect of an offender who is convicted of a stage 2 offence or a stage 3 offence, which the court would, in the absence of that paragraph, have imposed a qualifying sentence. Now, so it's just not clear, to be honest, it's not clear to me, but I'm concerned whether that provision, in fact, limits the ability of a court to make an order under the Criminal Procedure Mentally Impaired Persons Act that person be, sent to a medical facility so that their mental health issues can receive treatment, because I don't understand that to be part of our kind of punishment regime to deprive people of health treatments. In fact, the opposite, that people in corrections should be getting health treatments, and in particular mental health treatments. I might have that wrong, but I'll give the Minister an opportunity, and I'll come back to my parole question.
Madam Chair. Honourable Minister.
Thank the member for his question. The changes that are being made to the availability of orders under the Criminal Procedure Mentally Impaired Persons Act 2003, I can see why the member has asked some questions on this. The bill as introduced actually restricted the availability of post-conviction orders for treatment instead of a sentence, when the court would have otherwise imposed a qualifying sentence at all 3 stages. This is intended to ensure that serious offending receives serious sentences, and to reflect that orders imposed instead of a sentence are typically reserved just for the minor offending. The majority of the Justice Committee actually recommended that the availability of the post-conviction orders under the Criminal Procedure Mentally Impaired Persons Act 2003 only be limited at stages 2 and 3 of the 3 strikes regime. There is no limit on orders at stage 1. It's not required because there are no mandatory penalties at stage 1. But because there are mandatory penalties at stage 2 and stage 3, we are happy with where we have landed with this.
Honourable Dr. Duncan Webb.
Say, just in response to that, that is extremely disappointing that people who are mentally ill and are in the correction system, by dint of this legislation, cannot be ordered, the orders can't be made to put them in a facility where they receive the treatment that they actually need. And I'm quite sure that that's in breach of our international obligations under the United Nations Convention known as the Mandela Rules. And that's actually quite disturbing. But I'll go to my second point, which is parole, and it's clause 22 of the bill, and these are amendments to the Parole Act. I'm just trying to find my place there. And it's about non-parole periods. Now, I get we don't agree with it, but I understand that if you're sentenced to your second strike, you don't get parole for that sentence. And the Minister has alluded to the fact that it is conceivable that people could be serving a sentence and be in prison and commit a strikeable offence. And so they will have 2 sentences. And it's even possible that the sentence that they're serving is a very serious one. They could be in prison for for murder and be sentencing a very long sentence. And in section 22, it's 3AB I'm concerned about. Because the provision provides an offender who is subject to an order made under section 103(2)A of the Sentencing Act, 3 strikes, is not eligible for parole in respect of the following sentences. The sentence to which the order relates, that goes without saying. Any other sentence to which the offender is subject when the order is made. Now, if that offender is in prison for murder, that is then sentencing them to life without parole. Life without parole. Because that's the sentence that that person is already serving. Elsewhere in the Act, there are quite different provisions around murder, which don't say life without parole, but they do state minimum non-parole periods for people on strikes. And again, I don't agree with it, but I understand it. But it looks to me here, and it's not just murder. It could be anyone being in prison for a sentence which is longer than the strikeable offence that they've committed in prison. So in fact, by committing that strikeable offence, you are actually subject to double jeopardy. You're punished twice. Once for you've been sentenced once, and because you've committed a strikeable offence and you're still serving your sentence, you're punished again by having your ability to apply for parole for that sentence removed. The worst position is in respect of murder, which, if I've got it right, and I can see there's some work going on behind you, but if I've got it right, that's life without parole. And there's only one person in New Zealand who's got that. And I'm pretty sure that's not the legislative intent. And it may well be that we need to come out of committee and go back into it to fix that up, because it's not an easy piece of drafting, but that's what happens with complex legislation of this nature.
Lawrence Yunnan.
Madam Chair. Thank you, Minister, for your response to my question on Section 14. But the Minister was saying that it is not required, but didn't answer my question, which is whether they are mutually exclusive. But I'm going to take that answer from the Minister as saying that they are mutually exclusive and they don't need to be considered together. Now, I do want to pick up on, and apologies if I didn't hear correctly, but when the Minister was going through my amendments, the Minister mentioned that my amendment for Clause 16 doesn't need to be considered, and my amendments for 20 to 22 doesn't need to be considered as well, because we already have provisions in place for manifestly unjust. But that wasn't, I may have misheard the Minister, but that wasn't what my amendments were on. But what I want to also remind the House as well is that we still haven't got a clarification based on what Honourable Dr. Duncan Webb mentioned earlier of what manifestly unjust really means. But in terms of Section 16, I am concerned that for someone who is mentally, based on the definition of mentally impaired in the Criminal Procedures Mentally Impaired Persons Act 2023, that they will not be considered because no order may be made under the new Section 16, subsection 6. No order may be made, and there's no wiggle room for that. If the Minister implies that manifestly unjust is already embedded as part of subsection 6, just again, one sentence clarification is all I needed. But if it's absolutely not considered, which is what is stated here in subsection 6, that then is deeply concerning, and particularly from the perspective of the disability activists and also the number of neurodivergent and also dyslexic and also people with severe mental trauma who might be put away much longer than they are required. So clarification on whether manifestly unjust applies to 16 subsection 6 is absolutely crucial in this case, because if it's not, and they gives no leeway to if someone is at a stage 2 or stage 3 offense, then I would like to ask the Minister what advice has been sought since this bill has been sort of in some ways redrafted since the Select Committee has been received from the Attorney General on the Section 9 of Bora test.
Honourable Nicole McKee.
Thank you, Madam Chair. Just going to go back onto clause 14, just to clarify again that this is a technical tidy-up. It's the current wording ensures that both are covered, and the current wording, as far as I'm concerned, is fine because it's the same as the previous regime. In regard to clause 16, the current drafting ensures that orders under section 34(1)(b) are only available for the lower level offences, that is, those less serious offences that are in line with current case law. Orders under 34(1)(b) apply instead of sentence. Orders under 1A are still available in all cases, and these will apply alongside the sentence. Speaking to clause 22, this is a remedial amendment correcting an error that was made when the three strikes regime was initially repealed in the Three Strikes Legislation Repeal Act 2022. It actually does not have anything to do with the three strikes regime itself, but because some of the provisions of the Parole Act in 2002 were repealed in error, we want to ensure that there is consistency between the Parole Act Section 1032A of the Sentencing Act 2002, and it's important that we make it clear that there is no parole eligibility for offenders currently serving this sentence, of which there is just one, and it's merely just putting back into legislation at the earliest opportunity the error that was made when the previous government repealed that provision.
James Meager.
A chance to contribute on this debate. I just wanted to essentially just start by just acknowledging members opposite for their contributions and for continuing to contribute and be here with us. We've all, I think we've all noticed the numbers and the votes at the moment, so I just wanted to acknowledge the commitment that we all have, because it can be tough doing this on a Friday when there are electorates and families and things that people could be doing. So I appreciate the commitment to the democratic process from all members opposite. Look, I agree with Dr. Webb. Dr. Webb mentioned that this is essentially an administrative part. It makes a number of consequential amendments to other pieces of legislation. First question to the Minister and the Chair is essentially, does she agree with that assessment, that it is an administrative part? It makes the amendments to other pieces of legislation that will operationalise the three strikes regime. And just the second point was just to Dr. Shunan's point, and to try and wrap this up around the manifestly unjust provisions. They are very well understood in case law. There's a reason why they're not defined in statute, because they are well understood in case law, including in Fitzgerald, which the member is very well accommodated with. And it's my feeling that we have covered that off in part one, and we shouldn't be relitigating the meanings of manifestly unjust, because we've already made a determination on that question. But so just to the Minister, is my understanding correct that this is essentially a gathering of about, how's my maths, 9 or 10 clauses which relate to essentially administrative functions of operationalising the regime in other statutes?
Madam Chair. Honourable Nicole McKee.
Yes, that member is correct. This is just about technical tidy-ups and ensuring that the legislation fits within different areas of law, and that they will all speak with each other. So it is very much just a technical side, and as I mentioned in the last part, one of them is a tidy-up from an error that was made under the previous government when they accidentally repealed something that they should not have repealed. And as I made mention, taking the first opportunity in the three strikes regime to fix that, and to reinstate it. But when we're looking at the Criminal Procedure Mentally Impaired Persons Act, the Sentencing Act, we need to make sure that they all align with each other to enforce this legislation once it goes through.
Dr. Tracy McClellan, and on the basis of the conversation that we've just had, I have noticed, and I've been listening to this debate in terms of part one since 10 p.m. last night, so effectively 4 hours, and I'm finding that there is a bit of repetition creeping in, and so I want it to be very precise and very administrative on the calls that we're going to have from here on in.
Thank you, Madam Chair. And this is my first call on part two, and I'm going to just continue with the line of questioning that's already been asked about the amendments to the Criminal Procedure Mentally Impaired Persons Act, because I'm still not 100% clear on that. I'm quite happy to do short, sharp questions as long as I can get some clarification. It's a genuine question to clarify where we're at in the differentiation between what is a first strike, a second strike and a third strike, and who is still able to have orders, even though they may be alongside sentencing, the difference between people who have forensic needs and mental health issues. So the Section 34 amendment, the Minister has just said in her first response to this question that therefore no orders will be available. On the second response to the question, she said orders will still be available alongside sentencing. But it clearly says that no order may be made under subsection 1B in respect of an offender who is convicted of a stage 2 offence or a stage 3 offence. So I've taken that, and I may be wrong, to say that if someone on their first strike is eligible, for lack of a better word, for an order to have be sent somewhere different, essentially to a forensic facility because of a impairment, almost certainly an Access 1 disorder. But if they're on their second strike or their third strike, that same pathway isn't available to them. So A, is that correct? And B, if it is, what is the rationale behind that insofar as, is it because on a first strike someone's presumably served over 13 months, therefore any mental health condition severe enough to require a Section 34 would have already been uncovered, or is, I'm just unclear as to why stage 2 and stage 3 are not included. So if the Minister could answer that. I have some other questions, but that would be good.
David McLeod.
I move that a debate on this question now close.
The question is that debate on this question now close. All those in favour, I'm voting please. The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Action New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
The ayes are 68, the noes are 43. The question is agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 14, replacing paragraph B and inserting a new paragraph C of subclause 4 be agreed to. All those in favour say aye. Aye. To the contrary, no. Aye. The noes have it. Party vote has been called for, please, Clerk.
New Zealand Labour. Oh, sorry, New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 opposed.
E ono waka ai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Dr. Lawrence Yunan's tabled amendment to subclause 6 of clause 16 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote, please, Clerk.
New Zealand National.
Votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand
8
First.
opposed.
Te Pāti Māori.
Ono waka ai.
The ayes are 43, the noes are 68. The question is not agreed. Dr. Lawrence Yunan's tabled amendment to delete clauses 20 to 22 is out of order as being contrary to the objects and principles of the bill. The question is that part 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E ono waka e.
The ayes are 68, the noes are 43. The question is agreed. To the votes on Schedule 1, the question is that the Minister's amendment to Schedule 1 set out on AP number 237 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E ono waka e.
The ayes are 68, the noes are 43. The question is agreed. Dr. Lawrence Yunan's tabled amendment to delete clause 19 of Schedule 1 is out of order as being inconsistent with a previous decision of the committee. The question is that Dr. Lawrence Yunan's remaining tabled amendments to Schedule 1 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti
Ono
Māori.
waka ai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Schedule 1 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E ono waka e.
The ayes are 68, the noes are 43. The question is agreed. Votes on Schedule 2. The question is that Dr. Lawrence Yunan's tabled amendments to Schedule 2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour. Is that right? No, sorry, can I correct that? 49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
He ono waka ai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that Schedule 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No, the noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour this time.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Ono waka e.
The ayes are 68, the noes are 43. The question is agreed. Schedule 2A. The question is that Schedule 2A stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti
He ono waka e.
The ayes are 68, the noes are 43. The question is agreed. Schedule 3. The question is that Schedule 3 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. The noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Waka e.
The ayes are 68, the noes are 43. The question is agreed. Members, we now come to our final debate. This is the debate on clauses 1 and 2, title and commencement. The question is that Honourable Dr Duncan Webb's tabled amendment to clause 1 to insert with retrospective effect to be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. The question is that too late. The question is that quiet, please. I'm voting. The question is that clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No, the noes have it. Party vote is being called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes.
Te Pāti Māori.
He ono waka e.
The ayes are 68, the noes are 43. The motion is agreed. Honourable Dr Duncan Webb's tabled amendment to clause 2 is ruled out of order as referring to an indeterminate event and not providing sufficient certainty. The question is that Maria Mino Kapakingi's tabled amendment to replace clause 2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
He ono tino wakai.
The ayes are 43, the noes are 68. The question is not agreed. The question is that clause 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakahei.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
He ono wakai.
The ayes are 68, the noes are 43. The question is agreed. The question is that Honourable Dr Duncan Webb's tabled amendment to insert clause 2A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
22 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
He ono wakai.
The ayes are 43, the noes are 68. The question is not agreed. I will report this bill with amendment.
The House is resumed.
Mr Speaker, the committee has considered the Sentencing Reinstating 3 Strikes Amendment Bill and reports it with amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. The Sentencing Reinstating 3 Strikes Amendment Bill is set down for third reading immediately.
Mr Speaker.
Honourable Nicole McKay.
Mr Speaker, I present a legislative statement on the Sentencing Reinstating 3 Strikes Amendment Bill. I move that the Sentencing Reinstating 3 Strikes Amendment Bill now be read a third time. I'm very pleased that this bill has reached its final stage in this House, and I would like to particularly acknowledge the work done by the Justice Select Committee. This bill gives effect to the government's commitment to bring back the 3 strikes sentencing law. The 3 strikes regime is a key component of the work this government is delivering to restore law and order. Keeping repeat serious offenders off the streets also supports the government's commitment to 20,000 fewer victims of violent crime by 2029. We are proud to be sending a clear message to offenders that there will be significant consequences for repeat offending. For too long, not enough priority has been given to reducing the harm to victims and communities that results from violent offending. This bill is one of the steps the government is taking towards changing that. To quickly recap, The bill reinstates a 3-stage sentencing regime so that offenders face increasingly tougher penalties when they continue to commit serious crimes. In general, offenders will be warned of the consequences of reoffending at their first strike and will not be eligible for parole at their second strike. For a third strike, offenders will have to serve the maximum penalty for the offence without parole. Offenders will be subject to the regime if they commit a qualifying offence and receive a qualifying sentence. The threshold is above 12 months imprisonment for their first strike and above 24 months imprisonment for their second and third strikes. We have also added the new strangulation and suffocation offence to the list of serious violent and sexual qualifying offences covered by the previous regime, increasing that list to 42 offences. We have actively listened to New Zealanders impacted by serious crime and responded to their calls for a tougher response. This is why we have lowered the first strike threshold and reactivated warnings from the previous regime that meet the strike thresholds. More broadly, the bill makes modifications compared to the previous regime to support the new regime's workability. These include imposing appropriately lengthy non-parole periods for people who commit murder of 17 years at second strike and 20 years at third strike. We'll be providing some judicial discretion to avoid manifestly unjust outcomes and address outlier cases, setting out principles and guidance to help the court's application of the new law, and allowing a limited benefit for guilty pleas to avoid re-traumatising victims and to reduce court delays. We'll be providing for when pardons are granted and addressing the use of mental health orders under the Criminal Procedure Mentally Impaired Persons Act 2003. Mr. Speaker, the government is pleased to be reinstating a 3 strikes regime that is workable and will endure. Serious repeat offenders will soon be facing the necessary consequences for their actions. I believe this new regime will enhance public confidence that law and order is being restored. ACT campaigned to see 3 strikes reinstated, and this formed part of the coalition agreement. The Sentencing Reinstating 3 Strikes Amendment Bill will help make our communities and victims feel safe again, as they are entitled to and as ACT promised. Lastly, we have provided for a 6-month implementation period before the regime commences. This will allow sufficient time to make necessary operational changes. The government is committed to the regime working as intended from day one. Mr. Speaker, I commend this bill to the House.
The Honourable Dr. Duncan Webb.
This bill, Mr. Speaker, is an example of the determination of this government to pander to a small section of the community, which it seeks to nourish its hateful approaches to law and order. The evidence is clear that this bill, and the Ministry of Justice's regulatory impact statement gave very clear advice that the better, well, someone says cheer up. It's a sad day for justice when we've got a bill which cuts across constitutional principle, makes and intentionally imposes disproportionate sentences, doesn't have the effect of reducing the number of victims, and in fact, if anything, will have the likely effect of increasing crime in our communities in the long term. And as I was saying, the regulatory impact statement says it won't have any good effect, but it will detrimentally affect many families, including families of Māori. And then we had many submissions, and we did have many submissions, form submissions, organised by the Sensible Sentencing Trust and by an email campaign by the ACT Party, which essentially said go harder, which is what the Minister has done against all advice. But the submissions you would expect to look to, like the Children's Commissioner, the New Zealand Bar Association, the Law Society, the Pacific Lawyers Association, the Human Rights Commission, Te Hangaroa Māori o Aotearoa, the Māori Law Society, and the Law Association, all opposed the bill. How many civil society groups like that, and Crown entities, how many supported the bill? None. None. But we're pressing on anyway. And of course, you know, I was astounded when I heard Paul Goldsmith talk about this bill as intentionally disproportionate. And what that makes it is an intentional breach of the New Zealand Bill of Rights Act, which actually provides that everyone has the right not to be subject to disproportionately severe treatment or punishment. And yet that government over there has actually said, the words came out of the minister's mouth, that it is intentionally disproportionate. You know, and for the minister in charge of this bill to suggest it's not retrospective is some kind of gymnastics. There are people today who are on no strikes, and once this bill is assented to, will be on 2 strikes. They will be sentenced, if they commit an offence, to a more serious regime than was previously the case because of things that happened in the past. You don't get more retrospective than that, you know. So it is in fact the current intention of the government to breach a fundamental principle of our criminal law, which is when you change it for future conduct, not in respect of past conduct. And I can hear the banal comments from the other side, but you know, I actually think the rule of law is important, and I agree that we need a criminal justice system, and I know that we will have prisons and the community requires punishment, but we are not in some police state where there's no relationship, no rational relationship between the offending and the punishment, but that's what this bill does. And of course, those people who tomorrow will be on 2 strikes or 1 strike, when they wake up, they won't know the change. They won't know the change. And even though the whole idea of this act is to deter people, because people ought to know that they'll be in for more serious punishment if they're on strike 2 or 1 or 2, well, that's simply not the case, because nobody's told them, and nobody intends to tell them. And do you know why no one intends to tell them? Because it's too complicated, because this is an entirely different regime. Someone has to sit there and take this confusing template and run it over every previous strike to see whether it complies. And I think I heard the minister say there was something like 700 first strikers out there. That's 700 criminal records that someone, this is an actual person, has to go through manually to check whether the sentencing meets the new strike regime. And we know that the systems, we've had the Ministry of Justice in, and they accept their systems are outdated and creaking. They've got a project in place which is 5 years away from completion to upgrade their computer systems to be effective. And so the likelihood of this actually working is very low indeed. You know, the fact of the matter is that, and then we've got the ridiculous situation where a person on a first strike will get a second first strike notice when they commit another offence imprisonable by between 12 and 24 months. So the confusing situation where you're on 2 strikes, but it's only 1 strike. And I was disappointed that the minister, you know, she batted away all of the suggestions in a quite derisory manner. And those last exchanges, which were in part 2, were some of the greatest concern. And the Minister, although she stood up and said no to amendment papers, there were 2 really significant points that were raised, and I want to put on the record that it appears that there's at least one situation when a person convicted of murder who commits an offence will retrospectively have their ability to have parole removed, and they will be in prison without parole for life because they committed another strikeable offence. That was put directly to the Minister. The Minister was given advice by her officials on it, and she didn't answer it. Now, that's a real problem. And then we had the disturbing proposition that people with critical mental health issues, severe mental health issues, if they are in prison on a 2nd or 3rd strike, cannot be referred to the appropriate treatment under the Compulsory Mental Health Treatment Act. That's actually a community safety issue, because these people, in almost all cases, will get out eventually. And they'll get out without having had one of the critical drivers of their offending treated. So this window dressing bill, if it was simply window dressing, and it was signalling that we're tough on crime, but it didn't have these very serious community harm effects, I could let it go, right? It would be like a silly piece of legislation, but I'd let it go and think, well, that's what the National Party does when its ACT Party coalition partner tells it to. But it's not. It's actually a vile piece of legislation. And I know the other side doesn't really care about human rights, but it does cut across human rights, but it's worse than that again. Because if it had the effect that they said, that might in some sense go some way to explaining why you're doing it. But all of the evidence has piled up. A mountain of evidence tells us that this bill will have worse criminal justice outcomes. And I'm not just talking about offenders. I'm talking about victims. I'm talking for periods of time unnecessarily and put in prison without the ability to get parole, so to have no incentive whatsoever to engage in a corrective process, to undertake rehabilitative programs. They will give the middle finger to the system. Yeah. There is absolutely no reason for them, because they're in for 8 years and there's no way, whatever they do, it's going to be 8 years. And at year 8, they'll walk out the door. And we heard from corrections that the prisoner most likely to reoffend is actually the prisoner who has served an entire sentence without parole, because there is no softening of the transition into the community, no arrangements, no work done to prepare them for that. The bill is vile. It takes us backwards. It's an abhorrent contravention of our human rights.
The question is that the motion be agreed to. Dr. Lawrence Unan.
Thank you, Mr. Speaker. Now, I want to start off by summarising some of the conversations that we had during the committee stage. I think the first thing that we've noticed with this bill is that there has been no conclusive evidence that the previous 3-strike regime worked. This is not an evidence-based piece of law. This is part of a contract. It is a KPI that is being ticked off at the expense of everyone in Aotearoa, New Zealand. When we are looking at this bill between the Select Committee stage and second reading, there has been substantial changes in this bill, Mr. Speaker. The Minister said that was because she's listening to the people of New Zealand. But who are these that she is referring to when we see those who are most affected, when we see the legal experts saying something otherwise, I will come back to victims. Thank you. The Crown Law's advice for this was, in some ways, says that there would be an improvement based on the original bill. But as we see post-select committee, a number of areas has been introduced, including lower the threshold to first offense from 24 months to 12 months, so more people can get their first warning and their first strike. That was not the Crown Law's advice. Nor was it the Crown Law's advice to have a retrospective element. And when we asked the minister, what advice has she received since the amendments to this bill, she said it was privileged. Now, Mr. Speaker, Bora report is not privileged, but we have not seen a Bora report on the updated element, including the retrospectivity of this bill, according to the Ministry of Justice's own website. This is deeply concerning because we have seen under the previous law that it violates Section 9 and Section 9 of the Bill of Rights. And with the introduction of retrospectivity, it violates Section 26 of the Bill of Rights Act. Yes, we do need to have consequences, I agree. Yes, we do need to ensure that we put victim at the focus. But is the government willing to do that by violating one of the fundamental documents of this country, which is the Bill of Rights Act? Apparently, they don't care. But if we're looking at some other elements of the committee stage, Mr. Speaker, it is also the most peculiar thing that we have seen in this committee stage altogether, where the minister attempts to shut down some of the discussions by reading out every single person's amendment paper and saying that she will not support it as a way of not engaging with the genuine debate as intended of the committee stage. But there are some genuine concerns in here as we have addressed in this during the committee stage. We have not addressed the fact, and no one was able to answer the fact, whether the increase that we are seeing in crimes today was a direct result and has direct correlation with the three-strike regime from last time. That topic was not explored during this debate, and that, I think, deserves further attention and further research. We have seen the fact that parole is not to be, there will be no parole for people who are on second or third warning, and that is something introduced in here. What is that going to do for the rehabilitation effort? Now, the minister talked a lot about rehabilitation during the committee stage. Now, let's look at it from a behavioral psychology perspective. If you know that you have no chance of leaving, why would you bother? Why would anyone bother if you're not going to be able to get out anyway? There's no opportunity for parole. What's the point? What is the point? Some of those, these laws then fundamentally challenges and perpetuates the harmful practice that we're seeing in our justice system right now. Now, we know that there is going to be more people, more Māori, more Pacifica who are going to be harmed by this particular piece of legislation, Mr. Speaker. We are going to be seeing, I will be coming to the victim point, thank you. Now, when we are looking at this piece of legislation, it says nothing about restorative justice. It says nothing about rehabilitation. It is a knee-jerk reaction, and we have heard that from some of the submitters as well. Yes, we do need to put victim at the center of this, but this is not what this bill does. This bill has one job, which is to further entrench the discrimination that we're seeing in Aotearoa and to further take a punitive approach to our justice system. Punitive justice is only one form of justice, Mr. Speaker. There are other ways of justice. Restorative justice, for example. Will the victims actually get any support from people being further in jail? We're putting more and more money, we're tossing more and more money, having more and more prison beds in order to address the increase that is going to be caused as a result of this bill. We're going to see an increase in prison population. That does not help the victims. It does not help the victims of Aotearoa. It does not help the victims of crime that is committed in this country, Mr. Speaker. Now, when we are looking at this particular bill, now what is a victim-centered approach? Restorative justice is a centered approach. Preventative is a centered approach. I like the fact that the government members continuously to talk about victim, but why do we need to have victims in the first place? We ask that to the submitters. Now, in order for this bill to be triggered, there need to be crime committed in the first place. It need to be victims in the first place. Why are we doing that? Why are we taking the ambulance at the bottom of a cliff approach? Why can't we envisage an Aotearoa where we don't actually have victims? This is the thing. I like the fact that the government parties talk about victims. They are important, but it was even more important if we mitigate the crime in the first place. It is important for us to ensure that people are supported in terms of mental health. It is important that we're lifting people out of poverty. It is to ensure that we do take a totality approach when we're looking at this, particularly when it comes to the disproportionate number of Māori who are affected both as offenders and as victims. But that can only be achieved, Mr. Speaker, if we take a totality-centric approach, because what is good for Māori is good for everyone. And I'm saying that as a tangata tiriti. It is important that we have sufficient housing. It is important that we allow children to be lifted out of poverty, that we have a world-class education system where our tamariki, our rangatahi can dream in the first place. You talk to any child, no one will say, you know what I really want to do, I really want to have 3 strikes. That's what my life goal is. No child will say that. They are a circumstance of the system and the society that we have put them in. And we can change that. We can change that, Mr. Speaker, but not through this bill. This bill will achieve nothing than to spend more money on an approach that is the ambulance at the bottom of the cliff. It will put more money and more resources away from things that truly matters from a preventative perspective into a punitive approach. And fundamentally, I would say that everyone in this House agrees that we need to take those preventative approach first. This bill, Mr. Speaker, does not do that. What this bill does, it kicks the problem down the road. It is kicking the bucket down the road for future generations to deal with, because we can't be bothered dealing with some of the harder issues right now. So with that, Mr. Speaker, the Green Party will not support this bill.
James Megan.
Thank you, Mr. Speaker. Look, we support the bill on this side of the House. I want to acknowledge the passionate contribution from Dr. Shu Nan. I think he'll be spending a bit more time with the Justice Committee, and I'm glad for that, because he is a passionate, intelligent and I think well-intended Member of Parliament, but he's got this one wrong. And there's a couple of problems with his contribution. First of all, Dr. Shu Nan says this will lead to more prison beds. Well, if it's a choice between more prison beds and fewer deathbeds, then we'll take the fewer deathbeds any day of the week. And Dr. Mr. Shu Nan raised points around that this does little around restorative justice and rehabilitation and prevention. And of course, because this bill is intensely focused on deterrence and detention. That is the legitimate part of our criminal justice system, a fundamental part of the criminal justice system which the public supports, that this bill addresses. If the members want to support restorative justice programs, they would have voted for the budget which funds those programs. If they wanted to support rehabilitation, they would have voted for the budget in the Corrections Act which introduced rehabilitation for prisoners on remand. If they wanted to vote and support preventative action, they would have voted for the budget which established the Social Investment Agency and endorsed the government's social wellbeing approach. They are the things that are going to meet the drivers of crime and prevent these crimes from happening well into the future. Mr. Speaker, we support this bill in the House. We support it through second reading, all through the very good committee stage. We'll continue to support it, and I look forward to seeing its passage in due course.
Mr. Speaker.
The Honourable Casey Costello.
I would like to pause for a few moments just to reflect on the history of the journey of the conversation about victims. And I think in the early 2000s there was a quietly spoken, very passionate gentleman, Garth McVickers, who for the first time in my recollection started to talk about victims. And he formed the Sensible Sentencing Trust, and he fought and he advocated in a quiet and methodical way to highlight how skewed our justice system had got because we had lost sight of the victim. And we saw time and time again lives ended and lives destroyed by offenders that had committed heinous and horrible crimes and came out to do them again. And in his quiet and methodical way, he worked and he advocated, and eventually we saw the original 3 strikes legislation come into law. And when people in this House talk about its effect and its impact and how the repealing made such a significant change to the rights of offenders, and yet we saw in the last 6 years the increase in violent crime, and they stand in this House and say reinstating it is not the path we should take. The member, Cameron Brewer, brought some logic into this debate when he recognised that we look at the numbers. We get told so much about not looking at the facts and where's your evidence. And he reported the account at the time when it was repealed that we had 13,400 convicted on first strike, 744 on second strike, and 26 on third strike. And then again, we argue, no, it wasn't working. The point is, it took the previous member from the Green Party nearly 5 minutes to actually start mentioning victims. And we're speaking on the bill because the purpose of the punitive justice system is to actually prevent them making more victims. And that is the purpose of a legislation that looks at this specific aspect of how we deal with serious recidivist offenders who continue to make more carnage and more victims. But the upside is the fact that in this government, we know that this isn't the solution to reducing crime on its own. We know that there is investment in education that is essential and prioritised. We know that we have to break the cycle of people being trapped on welfare dependency and give them the dignity and honour of a career and a job and allowing them to achieve their potential. This is one component that says if you do not want to go to jail for a long time, then stop committing crime. Yes, and we can talk about Māori because I love that narrative. I love the amount of victims that are being created over and over again. 60% of them are Māori, and we need to stand up and say we will stop them being made victims. We will empower and we will respect them because we will not allow them to be victims.
I am going to ask members to not have a conversation across the chamber. You can have it out in the hallways. The Honourable Casey Costello.
So I'll return to the point of this legislation. We know that it has worked.
We question whether there should be minimum thresholds at all, and that will be told through the passage of time. But the point is that this is about making sure that those who commit these heinous crimes, and we have to remember the level of seriousness of the offences they are committing, the harm that is caused. Because when you have looked in the eyes of the rape victim, when you have cleaned up the homicide scene, when you have seen the harm that is caused, and you tell them that this is a person that has already committed this several times before, then that's why you know that sometimes punitive is exactly what we need to prevent the creation of further victims. And that is why New Zealand First will support this bill. We are glad that it's being made back into law, and we look forward to the impact on reducing the number of victims that we have to look in the eye in New Zealand. Thank you, Mr. Speaker.
Next call.
Swig. Tēnā koutou. Kei te pika, e te māngai o te whare tēnā koe. Ka tima tāku kōrero ki te whakamihi I ngā rangatahi o te aho matua. Tēnā koutou, I roto I te wikiha. Nau mai ki te kūaretanga o tēnei whare. Ko rātou ki te whai mai te ia o te Pāti Māori. Me tēnei whare. I've got a speech here, but I think I'm just going to... Sorry, Himi, I'm not going to follow it. Let me start with victims. Oh, my Māori are overrepresented as victims. This bit of legislation, as described by every single legal association in the country, is utter rubbish. But, you know, they don't like evidence. They don't like legal opinion. They haven't got any ideas of their own. All they know how to do is rally up old white people's votes. Good on you, Cameron. Good on you fellas all in the Justice Select Committee. I know you were there listening to all of this the whole year. But come back into the House and tell us how it's such a great idea. Māori are overrepresented as victims. You know what Māori are victims of? Māori are victims of a deeply, long-lasting, racist justice system, dispensed by the police, dispensed by corrections. Māori are worth billions of dollars in jail.
Absolutely.
And you're happy to line up the ducks so that Māori can continue to be delivered to jail at a rate that is astoundingly high and astoundingly consistent. Now that's a champion blow for colonisation, but it is an indictment on the quality, the values, the deep, deep belief of this House in its own justice. That's what it is. It's an indictment on the lot. You know, in 1986, Moana Jackson began the first of 3 deep investigations into the New Zealand justice system. His first one was called He Whai Pānga Hou. In 1986, he discovered that there were an alarming amount of indicators that showed that racism exists not only in the system, but in the structure and in the attitudes of the people who run that place. All of it, justice, police, corrections. And unsurprisingly, it delivers the Indigenous population from point of interaction with the justice system to being locked up at a rate about 5 to 7 times faster than anyone else for the same set of circumstances. And you're going to sit here and tell me that Māori are over-victimised. Māori are the victims of the justice system.
Kia ora. Kia ora.
And it has been that way, clear as a bell, evidenced for over 140 years. Personal responsibility, he says, the fella who knows nothing about the history of it. Nothing. So take your personal responsibility and apply it to your job as an MP and producing societal settings that provide a future for the 30% of this country's workforce that are young Māori. You wouldn't know that, eh, Wanganui? You wouldn't know that it's above your pay grade. Kia pai, kia kaha koe, kia kaha koe. Hoki atu ki roto o Whanganui, whangaia e nei kōrero ki Aotea. Ka tere te kupu whakahe I a koe. Engari, hoki mai ki tēnei whare. So, here we are, dealing with an age-old problem. Oh, tēnā koe, te māngai. Here we are, te māngai, dealing with an age-old problem that has a list of evidence and data and numbers and statistics that would blow your mind, and we're still doing things like keeping up with laws that have been proven in the last only 3, 4, 5 years to be utterly failures. Oh, they say. Oh, yeah. Oh, because I can count and read, and this side of the house obviously can't. Well, here you go. Te Wikiha, that's where I've been this week. It was a hui of about 1,800 young rangatahi. They've all been through Te Homatua. They all know exactly who they are and how to move forward. And they will be the voices that will arrive to this house in the future with all of their mates, Māori and Pākehā, who actually don't believe in any of the rubbish you're peddling. You know why? Because they can read and count too. But obviously, you fellas can't. So here's a little bit of advice for you. He, whai, pānga, ho. Someone write that down so you can go and read it later. You know, you could go and see Puao Te Atatū before that, or any of the other 2 reports that Moana produced over 36 years, and they'll give you a helping hand. We do not support the bill.
It's one thing to stand up and say that we all want everybody to be safe, and the other one is to weaponize the experiences of victims to reintroduce policies that are not based on evidence, that actually do a disservice to the very same victims of crime, and that will entrench inequities in Aotearoa that many have warned us about. This government, once again, doesn't care for the evidence, the facts, or the experiences of people. We saw it yesterday when they introduced benefit sanctions that are completely just vibes-based, not grounded in evidence, and with the reintroduction of 3 strikes today. It's frankly shameful. And I know this as somebody who's been a victim of crime. I recount how in 2018, on Christmas season, I had people come into my house, literally while I was sleeping in my room, took away my belongings while they were armed. I don't want to hear people weaponize the experience of people who have been victims of crime to push through a bill that will do literally nothing. And I recount when I talked to my whānau in Mexico about my experience that happened on that week, whether incarcerating those people would have made me safer. I think about the fact that actually the interventions that need to happen are far more complex and take far more political bravery than a bunch of empty discourse that is not based on evidence from people across the House in relationship to crime. The reinstating 3 strikes amendment bill will literally simply entrench inequities, criminalize the poor, and will not do the things that researchers, that victims, that actually people who've been through the carceral system have told us actually help with rehabilitation. If this government was so serious about supporting some of the communities that are most at risk from violence, they would not be defunding our public housing sector. If this government was serious about supporting the communities who have been most at risk from violent crime, they would be committed to actually ending homelessness. If they were actually serious about supporting the victims of assaults, for example, and addressing the criminalization of ill mental health, they would be resourcing our health system to ensure that everybody stays well. But that is absolutely not happening. And I heard people talk about deterrence, but let me tell you what, we've seen how in countries where they have some of the most punitive measures when in relationship to crime, they actually have some of the worst crime statistics because they haven't done the hard work to invest in the things that actually prevent crime in the first place. This is why if you go down this slippery slope of putting these policies in place, you actually don't end up addressing the drivers of crime, and you end up just paying lip service to the people who have experienced violence throughout their lifetime. And I think it's honestly disingenuous for members across the House to talk about victims when the evidence that supports this bill tells us time and time again that this is not what this bill will do. That if anything, this bill will result in a larger prison population, in a prison system that has not been shown to rehabilitate people, that has been shown to actually entrench cycles of violence, cycles of poverty, and this government is turning their back on the evidence, turning their back on the lived experience of those who have gone through the carceral system simply to pay lip service. But again, look, let's talk to the people and the community. They themselves have spoken in recent polls about whether they feel any safer with the government's recent policies or even rhetoric. And actually, most people have said they don't feel any change. And if I think about the people who many of us on this side of the House actually organize with, formerly incarcerated people, people in low incomes, we know from their own experiences that actually we need to do the hard mahi to actually have housing for all, a good health system that stops criminalizing disabled people who are often in distress, who actually need a range of really complex interventions that require funding. And what they do not need is empty lip service from members of parliament who clearly do not know what they are doing. I think it's actually quite a scary thing to have the chair of the Justice Select Committee completely ignore the evidence, completely ignore the research of this bill. Like, how shameful it is to have somebody chairing a select committee in charge of this bill who actually doesn't give a crap about the evidence, who actually just decides to throw it away and not care because it's easier to pay lip service to a bill that will not actually make people safer. Just because they will feel it doesn't mean it will happen on the ground. I think what we need is a change of government, one that is willing to ensure that there's the resources to do the complex interventions to keep people safe.
Time has expired. Before I take the next call, can I remind members that interjections should be rare and infrequent? And also, if you want to have a conversation, plenty of places around the Parliament for you all to have a conversation, and acknowledging the high emotion in the room and the importance for all of you to be able to have your say. I call the next speaker.
Mr. Speaker.
Cameron Brewer.
Mr. Speaker, what another great day for law and order in this country. And what another great day for democracy. Something that this government campaigned hard on since 2022. The 3 strikes, the reinstatement of 3 strikes. And won't the public be happy today? Because that's why they backed us. They backed us to get on top of law and order. They backed us to get on top of the economy. And they're seeing some great results, Mr. Speaker. They're seeing ram raids down 60%. They're seeing foot patrols up 30%. They're seeing serious assaults down 3% and aggravated robberies too down 11%. And so the package is coming. The package is coming. It's being delivered. What we saw under the last government was crime just tracking up, tracking up, tracking up. They repealed this legislation and we just saw serious assaults and the likes of sexual offences continue to increase. And so, Mr. Speaker, this is a great day for law and order. This is a great day for the victims of New Zealand. I commend this bill.
The Honourable Jenny Anderson.
Tēnā koe e te mangai o te whare. It's a pleasure to take a call on the 3rd reading of this bill. If this government was actually serious about reducing the number of victims in New Zealand, they wouldn't pass this legislation. But they're getting things like evidence to get in the way of their arguments. And so it's important that we do point out the evidence and we do understand where the ball has been dropped on this one. This government has made it incredibly clear throughout this debate that they're not interested in evidence. They're not interested in the regulatory impact statement developed by the Ministry of Justice. They're not interested in international research, and they're not interested in the mistakes made in New Zealand's history. They want to blindly power on with their slogans and bumper stickers that make them feel good and can go out and tell everybody they feel safe in their beds. But the reality is it does the actual opposite of what they're proclaiming it will do. This bill first passed back in 2010. It was an ACT coalition deal back in then, and I was working in New Zealand Police, getting ready for the changes to the system when this new 3 strikes legislation was going to be put into place. I was involved in identifying which of those offences would be classified as a strikable offence and getting into practice how we would implement this in courtrooms and how it would be rolled out for police throughout New Zealand. There were some significant significant problems in the rollout. And the first time this legislation was implemented in New Zealand, it resulted in people not receiving a strike who should have been receiving a strike. It resulted in confusion in courtrooms, and there was a multiple instances of data that was not being used between police, corrections, courts, and the justice system. The questions we've continually asked of the Minister throughout this process still have not allayed those concerns, that those considerations have been taken into place as we put this bill back into action. And we will watch and wait to see how many instances there are when there is confusion as a result of the changes put through from this bill. We've heard from the Minister in the committee stage that because the threshold in this reinstatement has been I think lowered from the previous one, there's going to have to be an exercise where somebody goes and figures out whether they're up for a first or a second strike compared to the previous regime. I have no idea, as an official who worked to implement that, how the person is going to identify who those people are, where they live, how they're notified, and how the records within the courtroom can record that accurately in order to show that we have justice. And the point is, Mr. Speaker, is that those people on the other side of the House, they don't even care. They don't care how it's implemented or whether it's fair. They just like to talk about the fact that it's tough, and that's the only point here, and that is concerning. I spoke on this bill when it was repealed in 2022, and the points made then are the same points now. Deterrence doesn't work. It disproportionately impacts upon Māori and further entrenches inequalities within our justice system and our society. It creates more victims by increasing offending and continuing that cycle of reoffending. It's not interested in addressing the underlying drivers of crime. It is simply a bumper sticker that makes them look tough but achieves nothing. And Mr. Speaker, I look forward to the third stage of this, which will be repealing this bill in 2026. And I look forward to being able to do that and introduce a justice system that works for victims, that actually delivers outcomes for New Zealand's justice system, and it's not just a bunch of cowboys looking tough. Because what it demonstrates, Mr. Speaker, what it demonstrates is that this is a government with no new ideas. No new ideas. They've dialed the microwave up to reheat and chucked it back in there and put it on full, because that's the only answer they have in the law and order space, is to take old ideas, reheat them and try and make it look like something new, when quite frankly it doesn't. And the regulatory impact statement gives really good information, so full credit to those officials who took the time to actually read and understand what the legislation does. The main point in terms of what deterrence does, or the threat of having a greater sentence, all the research shows that it does not work for serious violent offending. Where it does work is white-collar offences, such as fraud and tax violations. So I'm sure there's a few members they might know who in that space, that maybe it'll be more effective for deterring those for white-collar crime, for tax evasions. Those are the areas where deterrence as a theory works, because the threat of punishment alone does not have an impact on someone committing a crime. It does not. And that is, the reality is, it is done on impulse, and it is often done sometimes under the influence of drugs or alcohol. Let me be clear, Mr. Speaker. No way should our society tolerate serious criminal acts. Serious violent criminal acts do need to be punished, but we have a system that does not want to make more offenders and to further entrench offending and to increase victimisations. And that's exactly what reinstating this three strikes system does. In the Ministry of Justice's 2018 evidence brief, it recorded crime rates for the three most serious offences: sexual assault, serious assault and also robbery, from 1996 to 2014. And what that research showed, based on the trends in recorded crime rates, it was concluded that there was quite simply no impact of the previous three strikes regime on reducing serious offending. Even though the government claims it did, and it did again, the research from New Zealand is that the last time this regime was put into New Zealand, there is simply no research to demonstrate that it had an impact on serious violent offending. So we'll watch those numbers again as it comes in. The second main point, Mr. Speaker, is that it stops the judiciary from doing their job. Under three strikes, judges must sentence offenders to the maximum sentence on those final strikes. It is an anomaly in New Zealand law because it severely limits judicial discretion at sentencing by requiring judges to do that. And it ignores, Mr. Speaker, the reality of what our justice system currently provides judges being able to do, which is preventative detention for repeat serious offenders, public protection and extended supervision orders, minimum periods of imprisonment and maximum penalties up to life imprisonment. All those opportunities for sentencing currently lie with justice. And what this bill does is it says the government, the executive knows better than judges and we're going to implement that. And it is simply taking away from the courts what they know how to do. The final point I'll make, Mr. Speaker, is a point that's been made very well across all parties in the opposition, is that Māori have been disproportionately represented in the past of the three strikes regime, and that will continue again. When we looked at the most, I think the hardest figure for me personally was those who received a third strike under the previous regime. 81% of those were Māori who received a third strike. Māori are significantly overrepresented in the group in this area, and this government knows that and does not care. If we are serious about getting on top of repeat victimisations and repeat offending, we would not be reintroducing a system that has such negative outcomes for Māori. And that is important to note what does work. We know that Te Pai Oranga Māori justice panels reduce reoffending. Intervening early on and addressing the root causes of crime and having justice that takes place on a marae setting gets people early, understands why they're offending and takes them out of the justice system. The 24 Te Pai Oranga panels funded under the previous government are working. That is how you get on top of victimisations. That is how you get on top of reoffending. It is not knee-jerk reactions like trying to be tough with a third strike bill. Mr. Speaker, I'd like to conclude by saying usually we see National Enact actually making a reasoned argument, looking at data, looking at outcomes, but when it comes to this space, they stray and they go to the push button of fear, of scaring the public and trying to look tough because they like to. People that lose at the end of the day are those people who are stuck in our justice system, who don't have access to mental health support, who don't have access to alcohol and drug treatment facilities, and who don't have opportunities to turn their lives around. Instead, they are further entrenched in a system that is disregarding of their rights, disregarding of their culture, and quite frankly, a system that keeps New Zealand in the dark ages. I do not commend this bill to the House.
Remanaka.
I too rise to add my thoughts here on the third reading of the Sentencing Reinstating Three Strikes Amendment Bill, a bill that I wholeheartedly support. We've heard a lot of conversations from the other side of the House about an apparent lack of evidence. Mr. Speaker, the evidence that I'm interested in is not the evidence of elitist academics in their little... Oh, it's wonderful to see Mr. Tagata back from holiday. We haven't seen him on the Justice Select Committee for quite some months after he got upset that I challenged a submitter.
I would like you to focus on the bill.
Welcome back from your holiday. The evidence I'm interested in, Mr. Speaker, is the evidence of the store owner in Takanini that has had to build a cage around inside his store for him and his family to serve customers from because of repeat serious offenders, Mr. Speaker. The evidence I'm interested in is Uday in Wattle Downs that was bashed all over his body when he was trying to open his store in the morning by repeat serious offenders. That's the evidence I'm interested in, Mr. Speaker, not elitist academics. And guess what, Mr. Speaker? The qualifying sentences that we're adding in, they're not jaywalking, they're not graffiti, it's things like aggravated burglary, robbery, causing grievous bodily harm with intent to rob. That's what we're doing, Mr. Speaker. That's the evidence that we're basing our laws on, and we commend this bill to the House.
Elena Williams.
Thank you, Mr. Speaker, for an opportunity to take a short call on this bill. This three strikes bill that was introduced under previous government, then repealed, is pretty unique in New Zealand. It prevents judges from considering the unique circumstances and evidence around the offending. That is something which does not exist in any other sort of offending. But these are laws which we see have been introduced at different times and repealed at different times in the jurisdictions around the world that we like to compare ourselves to. And I'll come back to that, about the evidence basis, because not only do we have New Zealand evidence, but we also have international evidence about how these laws work to incentivise and disincentivise different behaviour, which ultimately impacts on the rights of victims to be able to work these things through the court systems in a way which is fair. But, Mr. Speaker, I'd just like to begin my comments by saying that this law is not needed. This is not something that impacts on any of the people we are trying in this debate to help. The courts already have the equivalent sentencing provisions and options for serious offending. The limit on parole right through to the more serious life imprisonment without any parole conditions is something that judges can already impact on offenders. And so when we think about those victims who the member who has resumed her seat speaks about, we also have to consider that those are the offenders which are being considered right now by judges with exactly the kind of discretion that she is advocating for, that they will receive serious sentences and that serious offending is treated seriously by those judges. The three strikes provisions that we're seeing being introduced now have actually also been shown to have a disproportionate effect on sentences. There's little to show, Mr. Speaker, that the law as it existed previously had any deterrence or preventative impact on serious offending. And as my colleague, the Honourable Ginny Anderson, has said, where deterrence is most effective is in white-collar crime. But in this kind of offending, was shown over and over again by New Zealand researchers, not the elite, but the people who care about the system and have studied it because they want to show the evidence and how it impacts on real ordinary people. They have found over and over again that it isn't changing serious offenders' behaviour or patterns of offending in New Zealand. And what it does show, though, is that that disproportionate impact is excessive on those rights that are protected by the New Zealand Bill of Rights Act. The New Zealand Bill of Rights Act is important because it lets everyone in New Zealand understand exactly what their minimum level of human rights are, and that should be protected and that should not be impinged upon by Parliament's process of lawmaking. Ordinary people are being told here that in these situations where there is a political call for harsher punishments, their rights that they understand that are protected will not be protected by this government, and that's a shame. Mr. Speaker, we have to do everything we can in this Parliament to recognise the rights of victims. It's really important, and considering the impacts on exactly those people that Rema Narkley has spoken about is our job. So we have to create laws which actually work for them and actually deter offending against them. What's important to acknowledge here is that three strikes never did that. It does not achieve safety for victims in the way that government MPs are talking about it. And international evidence shows that, so let me talk about that. The research clearly shows that laws with a deterrence effect can discourage offenders, but what they discourage offenders from is pleading guilty. You see over and over again in jurisdictions who have tried this, that offenders who know they will be on a strike or a second strike or a third strike will do everything and anything they can to avoid pleading guilty, to avoid admissions, to avoid presenting evidence which casts them in a light. Well, that means, Mr. McCullum, that victims are dragged into a court system which does not serve them. They are dragged over and over again into a situation where they are presenting more and more evidence where if this law that is being passed today did not exist, they would not be back into the system over and over again. This actively impacts on many victims who will be in a system where they do not belong and they could have avoided. I want to thank everyone who made a submission on this bill, but I also want to acknowledge that the way that the Minister treated the submissions from the Sensible Sentencing Trust meant that there was a second bite at Cabinet for the retrospectivity provisions, which meant that most submitters were not able to submit on that very important part of the law and were locked out of that process. The evidence is clear. This bill doesn't help. It's bad law.
Paulo Garcia.
Thank you, Mr. Speaker. Mr. Speaker, restoring 3 strikes forms part of the National Party and this government's suite of actions that confirm our commitment to restore law and order in New Zealand. All reasonable minds in New Zealand would agree that law and order has deteriorated greatly over the past 6 years, especially the past 3. This is turning, this situation is turning, but more needs to be done, this legislation being one. I commend this bill to the House.
Tracy McKellen.
Thank you for the opportunity to take a call on the 3rd reading of this hideous bill. Mr. Speaker, we've heard from several contributors today who have quite rightly focused on victims, and that is always at the heart of any discussion, let alone any lawmaking, insofar as that is always what should be top of mind. And I don't think that anybody on this side of the House would ever deny that that is the whole purpose of reducing crime, is to reduce the impacts that people who suffer from crime on them. Of course, that is exactly what we should be talking about. The difference that we have before us, though, is how is the best way to go about doing that? We can choose a way that sounds good on the surface, that makes us feel better about having done something, that makes us feel as if we've resolved an issue or solved a problem, and then we can move on with the rest of our life, because let's face it, the people sitting in this House aren't typically those that are the victims of crime. So we can avail ourselves and remove that dissonance and that dread that we might feel of our responsibilities by just doing something. Or we can actually buckle down and inform ourselves and look at evidence and look at overseas examples, look at previous New Zealand examples, look at the New Zealand context, look at the huge amount of information that we have available to us at our fingertips should we want to actually be better lawmakers, and we should do that part. So, you know, on this side of the House, clearly we favour the latter. And to hear members on the other side, and one in particular, describe it as elitism and academic in the same sentence, I found quite appalling, and a move towards a popularism that we see overseas that we know only ends in one direction, and that is a watering down of confidence, a watering down of the faith and the hope that people of this country should have in our institutions and should most definitely have in this place. Mr. Speaker, as I said, if we were serious about doing something, then we wouldn't be doing this. And that is not the same as saying that serious offenders should not be treated seriously, that people who are recidivist, serious offenders do need to be dealt with so that society can feel safe, so that we can reduce crime, so that we can have fewer victims, and so that people can have faith in the criminal crime and law and order space that we're in charge of. But it's incumbent on this government, as I said, to do the things that actually work. And as we've heard, this one doesn't. There's very few people that agree that three strikes regimes anywhere in the world have been even remotely effective. And how do we actually measure effectiveness? We've heard several people conflate and confuse and try and turn things into correlations and causations that simply don't make sense today. And actually over the whole process of this piece of this bill. If it was that simple as simply introducing a three strikes bill, then it would have been resolved already. We know it doesn't work. We know evidence from California and the US, for instance, has shown that. But the means by which we choose to measure it is by deterrence or by public confidence. And the regulatory impact statement from the Ministry of Justice, the people that were actually charged with doing the work behind the scenes, of advising the minister, of advising the government, said that they weren't a fan of this. They would have preferred the status quo. And they said explicitly throughout that regulatory impact statement that it wouldn't work. And so why this government has therefore been hell-bent on continuing to introduce a lame duck when they know that they don't have any evidence, where we know that the minister literally said, we know, one of the ministers said, we know that it worked, and then repeated and went on to just talk about anecdotes and a mishmash of information, concept and some facts, but nothing that actually related or was provable insofar as working. So I find that really, really quite disconcerting. Mr. Speaker, throughout the process we then had a couple of things that just seemed a bit bizarre. We had this whole confusion around the warnings, and that tended to occur in two parts. First, we had the record-keeping side of things, where the minister said that there's essentially 6 months time to prepare for readiness, and we know that there have been big holes in the systems that we're expecting to do a lot of the heavy lifting here. We know that the court system doesn't have the capacity to date, and they've only got 6 months to get that capacity to make sure that all of the record keeping, which is kind of complicated in terms of who's got a strike, who hasn't got a strike, under what regime, under what changes between the two, under what sort of, what part of the continuum does that information need to be recorded so it's ready to be online when someone appears in court and then can be given that verbal warning. So that doesn't fill me with a lot of hope that is going to work properly, because part of the impetus for this bill is about public confidence. So if we know that it doesn't improve public confidence in the law and order space, three strikes in general, and then we implement it and it kind of falls over at the first hurdle because we don't have the operational capacity to actually make it work, then the public surely continue to lose confidence in it as well. And Mr. Speaker, that is on top of a system, a court system and a justice system that has had to face cuts, 6.5% cuts. And where those cuts were made tended to be in the back office roles, tended to be in the IT spaces, tended to be in all of the, and there's been specific projects in the justice sector that have been canned because they needed to make up the costs, those cost savings. And that is exactly the same space that we're now expecting to do all the heavy lifting here and make this operational. We also heard, Mr. Speaker, today through the Committee of the Whole stage, which was wholly unsatisfactory, where the Minister, I felt, was belligerent, didn't choose to answer actual questions, clearly did not take it seriously that amendments, some of which I think would have been welcome additions to the bill, and then didn't answer some questions to the point where we're now at this stage, at the third reading, straight after the Committee of the Whole, because this is this is under urgency, and we haven't had the chance to sit back and evaluate the veracity of some of the answers that we received in the prior stage, particularly related to Section 34 and the power of the court to commit offenders to a hospital or facility on conviction. And what we heard essentially that it limits the court's discretion to apply that treatment-focused orders for people on their second or third strike. And that doesn't really sit right on this side of the House, and I think that we deserved a little bit more time and a little bit of a stronger and more robust process to see that through. So, Mr Speaker, Labour Party certainly does not support this bill. We think it's a terrible bill. Fundamentally, we know that there is no evidential foundation for the three strikes regimen or for the three strikes regime in any way, shape or form. It is literally taking us backwards, figuratively and literally. And as I said yesterday, it's the epitome of a bill that would do that. The regulatory impact statement backs that up. There's no information to suggest otherwise. The only information or the only people that seem to be supporting this bill are the government members. They don't seem to be backed up by anybody other than the few people on the Sensible Sentencing Trust who emailed the Minister and therefore seem to cause the Minister to have a last minute change of heart. Where you could very clearly see that she was more concerned about being perceived as not going far enough than doing the right thing, that she, at the last stages, interfered with the select committee process and made those changes that we've heard about over the last couple of days. So it was particularly offensive, I think, that the Minister did that or saw fit to do that, but also announced it publicly before the Select Committee had the opportunity to discuss those changes. So all in all, I think it's a dog's breakfast. I think the process has been rubbish and it won't work, and we will keep a close eye on it, and we do not commend this bill to the House.
David McCarthy.
And I am the last speaker for this third reading of the Sentencing Reinstating Three Strikes Amendment Bill. And I'm pleased to stand on behalf of the government, which clearly is supporting this bill. And it is a bill that we campaigned on as a party. It was also part of a coalition agreement with the ACT Party. Yep. And the purpose of this bill is clearly to keep people safe, primarily as far as I'm concerned. And there are certain elements of the previous speakers. Thank you. Thank you, Mr Speaker. There are elements of the previous presenter's speech that I did actually agree with, and that was primarily around the fact that this here is about serious crime that is being committed on a repeated basis and keeping people safe. And as it clearly states in the bill, there are 42 qualifying offences, and these are the serious violent and serious sexual offences under the Crimes Act. So this is not about criminal, menial offences. This is the most serious stuff, particularly stuff that is against humans and against members of society. So I want to acknowledge the work on behalf of the Minister, Honourable Nicole McKee. I want to acknowledge the work by the Select Committee from around the House, the Justice Committee, a very busy committee, 28 different bills it has worked on, and a lot of work being done in that space there. And ladies and gentlemen, three strikes are back. Happy to commend the bill to the House. Thank you.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
22 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Action New Zealand.
Votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E ono ngā pōti whakahei te turene.
The ayes are 68, the noes are 43. The question is agreed to.
Sentencing, Reinstating Three Strikes Amendment Bill, third reading.
I call on Government Order of the Day number 5.
Therapeutic Products Act Repeal Bill, second reading.
Speaker, I present
a point of order, Arena.
Thank you, Mr. Chair. I was waiting for the end of the vote for that. Mr. Chair, there's a long-standing convention that voting is heard in silence. The reason for that is so that the clerk can count the votes correctly. In this circumstance, we're in urgency on a Friday when we only have one clerk. It is very important that votes continue to be heard in silence, Mr. Chair, and I hope you enforce that next time.
I take that point. It was quieter than usual for me, so if there was noise, I noticed it less. But thank you for that observation. The Honourable Casey Costello.
Mr. Speaker, I present a legislative statement on the Therapeutic Products Act Repeal Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
Mr. Speaker, I move that the Therapeutic Products Act Repeal Bill be now read a second time. Today, the Government is delivering on its commitment to New Zealanders to repeal the Therapeutic Products Act, the TPA. Repealing the TPA is about more than delivering on an election commitment. However, repealing the TPA means that the Government can continue its important work to prioritise timely access to quality health services. Repealing the TPA will also allow for better legislation to foster innovation within our healthcare system. The TPA was intended to modernise the current outdated regulatory framework for medicines, medical devices and natural health products. However, industry, practitioners and consumers told Parliament at the time and then told us that it didn't get the balance right. The TPA fell short of delivering simpler, more flexible regulation. The Government believes that health policy must ensure access to the right treatments at the right time without imposing undue burdens on consumers or stifling innovation. The TPA would have introduced unnecessary cost and regulatory hurdles, particularly for low-risk products, and failed to enhance healthcare equity or improve public access to critical medicines, devices or natural health products. Mr. Speaker, I'd like to thank the members of the Health Select Committee for their diligence in reviewing the Therapeutic Products Act Repeal Bill. I'd also like to extend my gratitude to the many submitters who wrote in to the committee. During public hearings on the repeal bill, industry leaders and health practitioners told us that the TPA risked obstructing the very innovations our health system needs. For instance, requiring New Zealand market authorisation for exported medical devices and natural health products, despite their compliance with international standards, would have discouraged exports. Fees and charges on natural health products would have made products less accessible here. Repealing the TPA addresses these concerns, ensuring that New Zealand's health policy is both practical and forward-thinking, without sacrificing the quality or safety of care. Our approach to the health system emphasises the importance of reducing regulatory barriers to encourage local innovation and to provide access to appropriate medicines and products. The repeal of the Therapeutic Products Act will not leave medicines unregulated. The Medicine Act 1981 will continue to apply, and the existing regulator MedSafe plays a vital role in ensuring medicines meet our standards for safety and effectiveness. However, the Medicines Act 1981 is out of date and does need to be replaced. While the TPA was not the solution, new legislation is required to allow New Zealanders to benefit from advancements in medical technologies without unnecessary bureaucratic delays. I'm pleased to announce the Government will repeal and replace the Medicines Act with a new Medical Products Bill. The bill will not only ensure timely access to medicines, but also support our innovators, health practitioners and patients. It will include provisions ensuring New Zealand's health system is resilient and able to respond to future health emergencies. A message that came through loud and clear in submissions on the repeal bill was that natural health products should not be regulated as medicines. I agree, and in hearing public and industry concerns in September this year, Cabinet also agreed that natural health products will be regulated under a standalone bill. This bill will be developed following engagement with the natural health product sector and the public. Work on a new natural health products bill will not commence until after engaging with stakeholders, and no decisions have been taken on the scope or approach to be adopted in the bill. On that note, Mr. Speaker, one of the things the dietary supplements industry has been saying for a long time is that it needs export exemptions to be able to compete internationally. We want to address this long-term issue for New Zealand companies and to make improvements to support our exporters. The government plans a further change to the Therapeutic Products Act repeal bill in the committee stage, which will move Dietary Supplement Regulations 1985 from the long-repealed Food Act 1981 to the current Food Act 2014. This is a first step that will allow for exported products to apply for exemptions from New Zealand labelling and composition requirements so that they can better compete in international markets. As a government, we have an ambitious goal of doubling exports in the next 10 years. Repealing the TPA now will allow better legislation to be developed that supports exporters and recognises New Zealand as a trading nation. Mr. Speaker, the Therapeutic Products Act repeal bill delivers on our promise to New Zealanders to get rid of a law that would have created unnecessary barriers to access and innovation. Repealing the TPA also sets the stage for us to put in place a better law that gets the balance right, and I commend the bill to the House.
The question is that the motion be agreed to.
Mr. Speaker, well, it was interesting to hear the remarks the Minister just read. They bear a lot of resemblance to the remarks I read when I introduced the Therapeutic Products Bill, as it was in the last Parliament, to the House. And in many ways, it's apparent that the goals of the government are the same as the goals of the last government in pursuing medicines reform. So why are we repealing the Therapeutic Products Act? Many of the arguments the Minister just outlined are good arguments for amendment of the Therapeutic Products Act. And in the areas, many of the objectives she stated are either already incorporated within the Act. For example, I notice in many of the some discussion on the Health Select Committee about novel precision medicine technologies like CAR T cells, all able to be regulated within the Therapeutic Products Act. The ability to deal with public health emergencies was a feature of the Therapeutic Products Act that is being repealed. The ability to properly regulate medical devices also contained within that Act, and an approach to natural health products that need not mean that they are treated as equivalent to medicines. Of course they are not. The Therapeutic Products Act was always about risk proportionate regulation, which the Minister also mentioned. So it seems to me that this repeal is for political reasons, the management of stakeholders' expectations around how they will, around how they interact with the legislation. Fine, that happens in politics, but the problem is that now we're back to 1981, and if this repeal goes through, back to 1981 in terms of our medicines regulation, and that is wholly inadequate. So what happens if there's a situation in the intervening period? Well, I know, because in the last Parliament we had to deal with COVID-19, and we had a public health emergency. Our only way to deal with the public, well, a key element of dealing with COVID-19 was a vaccination program, and we had no way of expediting the approval of the COVID-19 vaccine under the Medicines Act. And so my first ever piece of legislation I passed as saw through Parliament as a minister was the retrospective amendment of the Medicines Act under urgency for one vaccine. It illustrates how absolutely useless the Medicines Act is for dealing with public health emergencies. Now you might think COVID isn't happening again, But actually, we had another problem with the public health emergency in the Medicines Act later in the last term of Parliament, and that related to monkeypox. The monkeypox vaccine was not able to be even discussed publicly, really, under the Medicines Act because of restrictions on advertising. When I think it's Section 25 of the Medicines Act is being used. The Medicines Act is a wholly unsuitable piece of legislation for the rapid approval of medicines like vaccines that are needed in public health emergencies, and yet the government is taking us back to the future. The other problem with the Medicines Act is that it contains no framework for the regulation of medical devices. And so the challenge with medical devices is there are some that can cause an awful lot of harm, and that has been happening sadly in New Zealand within the context of our inadequate regulation. And the most distressing situation we've seen emerge publicly is the poor regulation of surgical mesh in New Zealand and the lack of framework that we had for preventing and dealing with that, and the response that has been ad hoc as a result. The Therapeutic Products Act was intended to be able to make sure that those sorts of things don't happen again. And it is not, there are chances of it happening again with medical devices. I am aware of certain implantable contraceptives that have had safety concerns raised about them as well. And so we need a legislative framework to make sure that these devices are able to be safe. And during this repeal, it is just another way in which the New Zealand public has to wait longer for this framework to be in place. So the government may well have a different view on components of this of medicines regulation, and there might be some areas where the government and the opposition disagree. But there is an awful lot of good that is being undone through this repeal, and it risks harm continuing. And I've outlined some of those harms as they relate to medical devices and vaccines. And I just think that that is something that those are actually real risks. And I've outlined 3 risks that emerged just in the last term of Parliament. So it seems to me that this repeal leaves us without a framework, parts of a framework that we would agree on in many areas. And I think that is ultimately to the detriment of New Zealanders and poses significant risks to people. The next area I want to touch on is some of the innovation that the Minister referenced that is possible through that is already possible through the Therapeutic Products Act. That includes the changes to prescribing rights that enable wider classes of prescribers to be able to prescribe, albeit within, but of course within well-defined scopes. This enables us to make medicines more accessible, still safely, and make sure that when we are challenged in many ways by health workforce shortages, New Zealanders are able to go to a more diverse range of prescribers in order to access their medicines. This is already in the Act, and yet we're going backwards to get rid of that and then waiting for a period for the government to come back with new proposals on all of it. I do want to reject the idea that by including natural health products, medical devices, new technologies and medicines in the same Act, they were all regulated in the same way. You know, of course not. Of course the Act had separate criteria for all of them. Of course they had separate processes. It may very well be that the government disagrees on how those processes should be. Fine. But why get rid of the Act altogether? It seems to me that it sends us backwards, and it means that there is just nothing in place except the old dunga of the Act, Medicines Act 1981. This is not responsible lawmaking. We could have been spending this time debating actually the things the government wants to change about the Act. I am aware the ACT Party has proposals about an expedited pathway for approvals of medicines. That seems like something Parliament should discuss because it it alters how our regulator makes decisions, and that's an interesting proposal. But instead, we're going back to the beginning. And how far, not only is it that the Medicines Act is from 1981, but when I was Minister of Health, I worked with a team at the Ministry of Health who have been working on this issue, I think some of them for 20 years. 20 years we have known we've needed to replace the Medicines Act, and we're just undoing all of the work that's been done, back to the drawing board, new sets of instructions, separating everything out, throwing out the baby with the bathwater. It is so unfortunate that this is the position that we are in, and not only is it an example of making a show of ripping up legislation so that you can go back to stakeholders and say that bill you had concerns about, it's all gone, we'll start afresh. But those stakeholders in many cases have been consulted with for over a decade. This is a public policy failure that is owned by that all parties have touched in some way, actually, and it is just, I think, such a loss to the environment and to New Zealanders, this piece of legislation that would have made significant advances, that large components of it everyone actually agrees on. So my message to the government is, you touched it last, you've broken it.
Members, the time has come for me to leave the chair. The House will resume at 2 p.m.